All right. Looks like we are streaming and recording. So this is Chair French, Chair of the Kansas Corporation Commission. I'm serving as presiding officer for this hearing, and I am now convening the hearing, joined by my fellow Commissioner Annie Keither. This is docket number 23 CONS 3169 CPEN, and it's captioned in the matter of the failure of Patrick Development Corporation operator to comply with KAR 823-120 and KAR 823-133 by operating under a suspended and revoked license. We will begin today's hearing with the entries of appearance, and I will start with Commission staff.
Good morning, Chair French, Kelsey Marsh, on behalf of Commission staff and the public generally.
Good morning, Mr. Marsh. And for operator?
Operator appears through counsel Jackson Ely of the Morris Lang Law Firm. Operator's authorized agent Cindy Patrick is also present.
All right. Good morning, Mr. Ely. We will now move to the notice of this hearing. Does staff have a recommendation regarding notice of the hearing?
Yes. Notice of this hearing was provided in the presiding officer's February 22nd order setting evidentiary hearing, which scheduled a hearing for Monday, March 18th, 2024, beginning at 10 o'clock a.m. via the Zoom video conferencing platform. The presiding officer's order was properly served on the parties. I would also note that Patrick Development's counsel is in attendance. Staff's recommendation is that notice is proper and the commission has the jurisdiction to hear this matter at this time and place.
Are there any objections to notice? Hearing none, and based on staff's recommendation, I will find that notice is proper. Commission has jurisdiction over the proceeding at this time and place. Let us now turn to preliminary matters, and I'll discuss the procedure of the hearing. Before I ask if the parties have any preliminary matters, I'm going to run through some of our standard disclaimers since we're doing this over Zoom. Since we are online and not in person, we understand some things can go wrong. And if any party encounters a technical issue, please just ask us to go off the record. We can then take a recess, resolve the technical issue, and then go back on the record once we've got that taken care of. Second, we do ask all participants to keep their microphones off or muted when they're not scheduled to talk. And if everyone would also please mute your cell phones in your offices, or other electronic devices, that would be appreciated. Third, so the parties are aware, if the commission needs to consult among ourselves for something like an evidentiary ruling, we'll go off the record and we'll enter into what's called a Zoom breakout room to discuss that, and then we'll go back on the record. Fourth, since we're doing this over Zoom, just please be very careful to identify what you're referring to if you're discussing pre-filed testimony, exhibits, or paper copies. We do have copies of all that on hand, so we should be able to follow along if you will just identify it clearly. With that, do the parties have any other preliminary matters they wish to take up before we go into the procedure of the hearing? Mr. Ely.
Operator has two, Chair French, that we would like to raise. First, we have objections to certain portions of Mr. Dooling's rebuttal pre-filed testimony. I flagged these issues for Mr. Myers previously. I'm not aware of whether or not he's brought them to the commission's attention yet, but I can identify those specific portions, and I would object to them as hearsay evidence and ask that they be stricken.
Okay. I could say, why don't you go ahead and renew your objection at the time that they are moved for admission, if you want to renew it for the record. I will tell you that Mr. Myers has flagged those for us and specifically given us the references. We've taken a look, and our ruling will be to overrule the objection based on, one, we're not completely sure they are hearsay, but two, as you know, we can relax the rules of evidence a bit to go ahead and hear the evidence, and then we may decide, to weigh it certain ways depending on how reliable we think that actual evidence is. So we will still be planning to allow that into the evidence. But if you wish to make that objection for the record, go ahead and make your objection when they move to admit the testimony.
Thank you, Chair French. And the second item that we wanted to address preliminarily is Mr. Patrick's testimony. Unfortunately, Mr. Patrick is not able to attend this proceeding as he has suffered a significant medical incident. Staff has indicated that they are willing to stipulate to the admission of his pre-file testimony as it was written and waive his attendance and cross-examination. For simplicity of the record, I would ask that we admit that now.
Is there any objection?
No objections, Chair French.
It will be admitted. Thank you.
Thank you, Chair French.
Chair,
All right.
if I
Go ahead.
may,
Yeah.
just for clarification, I know that the presiding officer has issued an order regarding Mrs. Patrick's ability to testify. And basically says it's inappropriate for her to provide direct testimony except to the extent operator desires to have Mrs. Patrick adopt any of Mr. Patrick's testimony as her own. Would it be appropriate now or later to get the specific page and line numbers that she is adopting?
So if there's a response, I'll allow it, but let me respond just very quickly as to what I understand is going on. My understanding is Ms. Patrick is not necessarily adopting his testimony, that we are allowing it in as Mr. Patrick's testimony. However, she is going to be available to answer questions that are within the scope of his testimony. Is that consistent with what the parties expected?
That is consistent with what I expected, Chair French, and I can even provide a specific area in the scope of Mr. Patrick's testimony, which Mrs. Patrick will be able to testify to, and that's going to be the notice in the mail issues. Okay. What my intent is, Mr. Ely, just so I think this is clear in Mr. In the pre-hearing officer's order, but my intent is for you to call Ms. Patrick. I will allow just very brief direct examination solely on foundation. So if you would like her to describe the scope of her duties and the knowledge of the operations of the company, just so the commissioners and staff has some understanding of the type of questions that she could answer. I won't be allowing any additional, direct substantive testimony. I think that's clear in the pre-hearing officer's order. But if you want to lay a little foundation for the scope of things that she might know about, that's sort of what we would allow. And then at that point, it would be Miss Patrick's testimony, essentially. But my understanding is Mr. Patrick's testimony stands alone as his own testimony. Is that okay with both of you?
That works for me.
Okay. That works for operator as well.
All right, very good. Anything further from the parties as a preliminary matter? All right.
Done for operator.
Very good. We will now move on to the procedure for the hearing. In regards to the procedure, the parties will typically be allowed to make brief opening statements. After opening statements, we will have the examination of the witnesses. After direct examination of each witness, there will be an opportunity for cross-examination by the other party, and then the commissioners will have the opportunity to ask questions, and then there will be an opportunity to redirect the witnesses. Any further examination would be at the discretion of the commission. Following the witness examination, I will allow closing statements, and we will arrange for filing of post-hearing briefs if the parties believe that's necessary. Then we will conclude the hearing. So we will begin with opening statements. Mr. Marsh, do you want to begin?
Yes, thank you, Chair French. May it please the commission. On November 7th, 2022, commission staff suspended Patrick Development's license for noncompliance with the penalty order issued by the commission in docket 23 CONS 3030 CPEN. Patrick Development's license was suspended because both the wells at issue and that penalty docket remained out of compliance with commission regulations, and the fine assessed by the commission had not been paid. Staff documented that license suspension in a letter that was sent to Patrick Development on that same date. The suspension letter provided Patrick Development 10 days to shut in its operations or risk being fined for operating under a suspended license. That 10-day deadline to have the wells shut in was November 17th, 2022. On November 21st, 2022, while Patrick Development's license was still suspended, commission staff inspected various leases belonging to Patrick Development and documented at least 3 different wells actively operating. Additionally, the documentation provided indicates that Patrick Development operated 7 leases while its license was suspended, producing a total of 553 barrels of oil, which sold for a little over $40,000. The commission has issued a heightened penalty of $25,000 in this docket. That penalty is justified by both the amount of oil produced by Patrick Development while its license was suspended, as well as its prior history of disregard for license suspensions. In the 10 years preceding the shut-in order issued by the commission, Patrick Development's license has been suspended 11 times. Additionally, Patrick Development has been found on 2 prior occasions to be operating wells after being directed not to. Here, Patrick Development does not contest that it was not operating while its license was suspended. Patrick Development contests that the penalty order, or Patrick Development contests the penalty order because it claims it was not aware that its license had been suspended by staff. Staff believes the evidence presented before you today will indicate that Patrick Development was properly notified of the license suspension. Staff respectfully requests that the commission affirm the penalty amount issued in this docket. Thank you.
Thank you, Mr. Marsh. Mr. Ely.
Commissioners, may it please the commission, this proceeding is about allegations that operator Patrick Development Corporation operated on a suspended oil and gas license. And accordingly, staff believes that a heightened penalty order of $25,000 is appropriate. There's no denying, and the facts are not in dispute, that operator conducted oil and gas operations during the period from November 7, 2022 to December 29, 2022. But the reason that operator did that is because it was completely unaware that its license was suspended, because staff never informed operator. The key issue in this case is notice and due process. Was operator given sufficient notice and due process in regard to its license being suspended? Because if operator was not given sufficient notice and due process that its license was suspended, then that license suspension was ineffective, and operator cannot, by law, be found to have operated on a suspended license. Due process and notice are rights guaranteed under the Constitution. And as we work through the evidence in this hearing, it's important to keep in mind the standards set by both the Kansas Supreme Court and the United States Supreme Court, as stated in Board of County Commissioners of Reno County versus Atkins, a 2001 Kansas Supreme Court case, which quoted Mullane v. Central Hanover Bank Trust Company, a 1950 United States Supreme Court case. The first quote in that is, an elementary and fundamental requirement of due process in any proceeding, which is to be a court of finality, is notice reasonably calculated under all the circumstances to appraise interested parties of the pendency of the action and afford them an opportunity to present their objections. The second quote from that case is, when notice is a person's due, process, which is a mere gesture, is not due process. The means employed must be such as one desirous of actually informing the absentee might adopt to accomplish it. The reasonableness and hence constitutional validity of any chosen method may be defended on the grounds that it is in itself reasonably certain to inform those affected. The evidence in this case will show that the means the staff used to notify operator of its license being suspended was, in light of all the circumstances, nothing more than a mere gesture. And it was not reasonably certain to inform operator of that suspension. The evidence will show that staff knew about Mr. Patrick's health problems. Staff knew that the Patrick family was having difficulty with the mail service at their home. Staff knew that the mail that they were sending to operator was getting bounced back for reasons staff did not understand. Staff knew that Carrie Patrick had requested that staff communicate with him via email. And staff knew that these mail issues were so prevalent that staff made the internal decision to start mailing and emailing a copy of what they were trying to send to operator to make sure that it was actually delivered to operator. Despite all of that, the evidence will show that staff just threw the license suspension letter in the mailbox and never conducted any follow-up of any kind to make sure that operator actually knew that its license was suspended. Now, staff will likely seek to blame operator for this and claim that operator should have updated its mailing address, gotten a PO box, or checked COLAR more frequently. But all of these alternatives are being made by staff now with the benefit of hindsight. It's very easy for staff to go back and point out all the things that operator didn't do as things that should have been done. all while ignoring the efforts that operator did make. The evidence will show that operator was trying to work with staff and participate in a line of communication with staff. As it hears this evidence, the commission must place itself in the shoes of Carrie Patrick at that time and pose itself this question: was what Mr. Patrick doing reasonable in the light of the circumstances? Was what staff did or did not do reasonable in light of the circumstances? Unfortunately, this deficient notice is not an isolated incident in this proceeding. The evidence will further show that staff was consistently engaging in a pattern of behavior that was arbitrary, capricious, and setting operator up to fail. At the heart of this proceeding is operator's compliance with docket 23 CONS 3030 CPEN, specifically operator's actions relating to the TA status for the Bodley Pringle 7 and Johnson 7 wells. The evidence will show that operator was trying to comply with regulations and obtain TA approval for those wells, but staff set operator up to fail. The evidence will show that after the penalty order in docket 3030 was entered, staff moved the goalposts and changed its reason for denying the TA applications. The evidence will show that staff knew that Carrie Patrick was confused about the TA status of those wells, but staff knowingly allowed him to continue in that mistaken belief until it could impose this heightened penalty for $25,000. The evidence will also show the staff moved with lightning speed when it came to penalizing operator, but when the time came to actually help operator and unseal operator's wells, staff delayed and drug its feet. When all the evidence is laid out before the commission will see on one hand a very sick man who was trying to run his company and do the best he could, but he got confused. And despite his open line of communication with staff, he was never corrected and never informed of these issues until it blew up into the heightened penalty order before you today. And when that man finally did find out he was non-compliant, he had everything fixed within 24 hours. On the other hand, you'll see staff moving goalposts by changing reasons for its actions, prioritizing penalizing operators over helping them, and intentionally failing to provide information to operator, which could have solved this matter long before it blew up into what is before you today. There were multiple opportunities where all it would have taken to resolve this would have been a simple call or an email from staff. But each and every time staff was presented with that opportunity, it didn't say a word to operator about what was actually going on. The commission will be asked to consider whether it's appropriate to impose this penalty and this heightened fine onto operator. Staff's attempt at justifying penalizing operator for past sins and dockets from almost a decade ago is improper. This penalty must stand on its own merits, and the evidence here speaks for itself. The evidence will show that a penalty in this matter is not justifiable, and a heightened penalty is even less so. For these reasons, the commission should rescind the shut-in order in this proceeding and order such further relief in favor of operator as the commission deems just and proper.
Thank you, Mr. Ely. All right. We will now move to the examination of the witnesses, and we will begin with staff. Mr. Marsh, do you want to call your first witness?
Yes, thank you, Chair French. Commission staff calls Ryan Dooling to the stand.
Good morning, Mr. Dooling.
Good morning, Chair French.
I need to swear you in before we continue. If you would please raise your right hand. Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, Mr. Marsh, go ahead.
Thank you, Chair French. Can you please state your name for the record?
Ryan Dooling.
Mr. Dooling, by whom and in what capacity are you employed?
I'm employed by the Conservation Division of the Kansas Corporation Commission at the District 3 office as a compliance officer and environmental compliance regulatory specialist.
And Mr. Dooling, what is your work address?
137 East 21st Street in Chanute, Kansas, 66720.
Are you the same Ryan Dooling who caused to be pre-filed in this docket direct testimony consisting of 6 pages and 2 exhibits on May 1st, 2023, and rebuttal testimony consisting of 7 pages and 1 exhibit on November 3rd, 2023?
I am.
Was this testimony created by you or at your direction?
Yes, it was.
Now that you're under oath, do you have any corrections to make to your testimony?
I do not.
If I asked you the same questions contained in your testimony today, would your answers be the same?
Yes, sir.
Do you swear the answers contained in your pre-filed testimony are true to the best of your knowledge?
Yes, sir.
Thank you. At this time, staff moves for the admission of Mr. Ryan Dooling's pre-filed direct and rebuttal testimony into the formal record.
All right, any objections?
None, Chair French, except for the objection previously noted,
Yes.
which I can raise now if you'd like.
Yeah, why don't you go ahead and just note it for the record?
Okay, for the record, page 6, line 12 of Mr. Dooling's pre-filed rebuttal testimony, I would object to his hearsay, specifically the statement, quote, Mr. Hasselrod stated nothing had been done yet to bring the wells into compliance. The second statement is page 6, lines 13 through 14, quote, Mr. Hasselrod did ask the question of what was needed to be done at the Bodley Pringle 7 and Johnson 7 wells to bring operator into compliance. The third is page 7, lines 6 through 7, quote, however, as I stated earlier, Mr. Hasselrod has already informed staff that nothing had been done to the wells. Those would be the portions that operator would object to.
All right, as I previously explained, we're gonna overrule the objection on the basis that, one, we're not sure those statements are hearsay in the sense that they were either personal conversations he had or conversations with staff, and Mr. Dooling is speaking on behalf of staff. But also to the extent they are hearsay, we would allow them in and give them the weight that they are due, given what knowledge we think he would have had in those conversations. So as I said, it's overruled, but we do have your objection for the record, Mr. Ely.
Thank you, Chair French.
So with that, if there's no further objections, we will admit Mr. Dooling's testimony.
Thank you. At this time, staff tenders the witness for cross-examination.
All right. Go ahead, Mr. Ely, if you have cross for Mr. Dooling.
Thank you, Chair French. Mr. Dooling, my name is Jackson Ely. I represent the operator in this proceeding. I'm going to ask you a few questions about your prior testimony, okay?
Yes, sir.
In your pre-filed testimony, you stated that operator's license was suspended for non-compliance with the penalty order and commission docket 23 CONS 3030 CPEN. I'm going to call that the 3030 case from here on out. How specifically was operator non-compliant with the 3030 case?
And the 3030 case, it was, if I'm correct on this, that was for 2 violations of 82.3.111, which is temporary abandonment applications that had been denied past the deadline, and we recommended penalties for those 2 wells.
Is it fair to say that essentially operator didn't provide staff with what staff wanted for the TA applications for the Bodley Pringle 7 and the Johnson 7 wells, and staff did not approve the TA applications for those wells for that reason? Is that fair to say?
They were denied because the information provided was either not updated. The first time was a fluid level, and the second time, whenever he did reapply, they were denied again because the casing was not shut in.
So operator is facing a fine in this case because it didn't give staff what staff thought was necessary for the TA applications for the wells. Is that correct?
What the regulations say is what he did not provide. Yes, that is correct.
Mr. Dooling, do you believe that this proceeding would be occurring if it wasn't for those TA applications getting denied in the previous case?
I do not deny that. No, if he would have, if they would have been approved, he would have been okay under the 82.3.111, then yes, we wouldn't probably be here today. I mean, we're here for a different docket, but that's what eventually led to this current docket.
Let's look at what operator may or may not have done to try to be compliant with the 3030 case. Let me ask, why specifically did staff deny the first set of TA applications for the Bodley Pringle 7 and the Johnson 7 wells? What was the first reason?
The fluid level, you have to, every year you have to reapply for application for 82.3.111, and he did not provide a current fluid level. The fluid level that was provided was from 2021. So that was the first reason for denial was we asked the operator to obtain a current fluid level and to resubmit the application And at that time, that deadline was set for, I believe it was June 25th of 2022 is when the deadline was set to reapply for TA status.
I'm gonna try to share my screen here. And is everyone able to see my screen? I'm looking for something that should be showing operator exhibit 2B. Is that
Yes, we see
visible?
it.
Okay. This is operators exhibit 2B as it was attached to the pre-filed testimony of Carrie Patrick. And go down here.
Mr. Ely, you may want to zoom in just a little bit.
Is that better, Chair French?
I think that's readable. Yes, thank
Okay.
you.
It's hard for me to see what everyone else in the call is seeing. So if I need to adjust my share, please let me know if it can be more legible.
Yeah, and it may be on Mr. Dooling to tell you if he can see it or not.
Okay.
I think I can see it okay, Mr. Ely. Thank you.
Okay, Mr. Dooling, is this the first TA application that was submitted for the Bodley Pringle 7 that you referenced?
Could you scroll down just a little bit so I could see? Yes, that appears that one was denied on May 26th. So yes, that would have been the first temporary abandonment application that was denied.
Okay, and so the fluid level that you're talking about, is it this right here where it says casing fluid level from surface 825? Is that what you're talking about?
That is correct.
And the date here was April 15th, 2021, correct?
That is correct.
Okay. And I'm going to go down. Is this the same timeline, the TA application for the Johnson 7 well?
Can you scroll just a little bit more downward, please? Thank you. Yes, that was the same time frame. That was both first time for the Bodley and the Johnson.
Okay, and this casing fluid level from surface 820, that's what we're talking about here. Same
Yes,
fluid
sir.
level that was out of date. Okay.
Yes, sir.
Did operator provide an updated fluid level?
I believe he did. I believe, I'm not sure it's in your exhibits, but he did file another temporary abandonment application for those two wells. And I believe he actually filed the second ones on, I believe it was August the 5th, which was a month and a half, 2 months after the deadline.
Okay, I've scrolled down to what's been marked as operators exhibit 2C as it was submitted with the pre-filed testimony of Carrie Patrick. Is this the second TA application for the Bodley Pringle 7?
I'm going to say yes, because it has an approval or a denial date of August 16th on that one. So yes, that would be the second one.
And then is this the second TA application for the Johnson 7?
I would agree with that. Yes.
And so both of those are attached as a part of operators exhibit 2C. I'm going to state that for the record. Do these applications, the August applications, do they show an updated fluid level?
It shows that they got the fluid level on this form here on July 14th of 2022, which would be adequate.
What was the updated fluid level for the Johnson 7?
It was 825 foot recorded on July 14th, it says.
What was the updated fluid level for the Bodley Pringle 7?
It says they found fluid at 830 feet, and it was reported that they took it on July 14th of 2022.
Is there a notable change in the fluid level between those two sets of reports?
I do not believe that there was a huge change in the depths of fluid. No.
And you might have stated it, and I apologize if I missed it, but when did you say the second set of TA applications, when were they denied?
They were denied on August 16th of 2022.
Is this letter that's also in Exhibit 2C, Operators Exhibit 2C, is this providing the reason why they were denied?
That is correct.
What was the reason?
Lack of surface control.
What was the previous reason given on May 26th? Was that lack of current fluid level?
That is correct.
So operator corrected the issue from the May TA applications on the second set, correct?
Would you repeat that, sir? I'm sorry.
The operator corrected the issue for the first denial when he submitted the second set. Is that correct?
The operator corrected the reason, the first reason it was denied at the first time. Yes, the reason the lack of surface control was denied the second time was, under 82.3.111, I believe it's under C. We cannot approve or a CP 111 unless pollution of fresh and usable water is determined that it cannot pollute fresh and usable water. So until staff went out to investigate the wells for approval, that's when we found that the operator did not even have surface control on these wells.
Mr. Dooling, was surface control listed as a reason from the May denial letters?
From the May ones, no, it was not, because we were under the impression that the operator would have the wells shut in with surface control before you'd even apply for temporary abandonment status, since you have to have surface control to get an approved CP 111.
So the reason for the denial between the two sets, it changed though, correct?
Well, it didn't really, if we would have went out and investigated beforehand, we would have found that. I mean, obviously there was no reason to go future on because the fluid level was not.
Mr. Dooling, I'm going to cut you off there. I need you to answer the question I ask you.
Okay.
Did the reason for the denial between the May set and the August set, did the reason for the denial change, yes or no?
Yes, sir, it did.
Mr. Dooling, what are the risks associated with the lack of a cap or a swedge on a well?
There is a risk of pollution of the fresh and usable water and the escape of fluids from the casing.
I'm gonna read from the regulations KAR 82.3.111 for a moment, and when I'm done, I'm gonna ask you if that reading is consistent with your understanding of the regulation.
Okay.
KAR 82.3.111 subsection C, the right of denial. After an application for temporary abandonment has been filed, the well shall be subject to inspection by the Conservation Division to determine whether its temporary abandonment could cause pollution of fresh and usable water resources. If necessary to prevent the pollution of fresh and usable water, temporary abandonment may be denied by the Conservation Division, and the well may be required to be plugged or repaired according to the direction of the Conservation Division and in accordance with its regulation. Is that reading consistent with your understanding of the regulation?
Yes, sir, I believe so.
So staff has the ability to deny a TA application if it is necessary to prevent the pollution of fresh and usable water. Is that correct?
That is correct.
How can fresh and usable water be polluted if there's not a cap or a switch on the well? How can that happen?
If the field pressure is up and pressure's fluid from the production zone up, there's no way to keep it inside the casing. It can be spilled on top of the soil, and fresh and usable water above, the surface water also. So that's how, you cannot contain fluids if a casing is not closed in.
Okay, so correct me if I'm misunderstanding this. If there was nothing else wrong with the well, the only risk to fresh and usable water would be if the fluid rose up and spilled out the top of the well. Is that correct?
That's one of the issues. Yes, you can also have commingling from downhole, but in this instance, that is the most aspect. Yes.
Okay. And that could happen if there's not a cap or a swedge on the top of the pipe, right?
Of the casing, yes.
Casing, yeah.
Yeah.
So Dooling, I'm going to share my screen again here. I'm gonna go, I'll just pick one. I'm trying to show you, I believe this is Operator's Exhibit 2B, the TA application for the Valley Pringles 7. Mr. Dooling, what is the total depth of this well?
Total depth is 875 foot is what it was reported as.
And what's the fluid depth again?
The fluid says that they found fluid at 825 foot.
I'm gonna go to the Johnson 7-1 of the same exhibit. What's the total depth of this well?
Total depth, it says it's 850.
What was the fluid level?
It was reported at 820 foot.
So that fluid's pretty far from the surface, isn't it?
At that time it was, yes.
It's essentially at the bottom of the well, is that right?
Towards the bottom, yes.
Mr. Dooling, you stated previously that there was no significant change in the fluid level between the May TA application, which had dates from April of 2021, if I believe, and the August set of TA applications. Is that correct?
That's correct. The fluid levels that was reported was fairly similar to what was reported on both applications.
So there's no indication that the fluid level in the wells was rising, is there?
Could you repeat that? I'm sorry.
There's no indication that the fluid levels in the wells were rising, is there?
Not from what was reported at that time, no, sir.
Do you realistically expect the fluids in the wells to rise over 800 feet all of a sudden and spill out the top of the well when there's no indication of rising fluid in the wells?
Objection, calls for speculation.
Chair French, we have testimony in here as to the risk of fresh water being whether it spills out the top. I want to know, in Mr. Dooling's opinion, as to whether or not that's a risk given the evidence that has been presented.
Well, then what's the relevance here? We're talking about TA applications from a docket that's now closed. You've previously stated that the issue in this docket is whether notice of the suspension letter was provided to Patrick Development. So I don't get how the TAs are relevant, or even how any of this information is relevant to the docket at hand.
If I may, this penalty order or this shut-in order specifically required compliance with the 3030 docket. That's the reason why we're here today. If the TA was unjustifiably denied because there wasn't actually a risk to fresh and usable water, then I think that's relevant to whether or not operator was not in compliance.
Then why was it not raised in the other docket where it actually would have been relevant instead of this current docket at hand?
The issues that we're talking about now are the compliance issues that operator undertook after the penalty order and the 3030 docket was entered, because that is what caused this reason in this case. I think it's important to talk about whether or not that compliance was even necessary under commission regulations.
I will let you briefly proceed, Mr. Ely, but I tend to agree that I don't understand how this is relevant to the legal question in this docket. But I will, why don't, if you could move on this pretty quickly, and to the extent Mr. Dooling can or can't answer your question, I do agree it requires some speculation. We've had multiple objections in here. So the first one was speculation. I'll overrule that objection. To the extent Mr. Dooling has the ability to answer that within his knowledge, I'll let him try. He can say that he doesn't know. On the second objection of relevance, while I tend to agree with staff that this has very attenuated relevance to the legal question in this docket, I'll let you briefly proceed on that as well. So you may proceed in summary, but let's try to keep this part of the examination pretty short.
Thank you, Chair French. This is actually my last question on this subject.
Okay, very good.
Mr. Dooling, do you expect the fluid levels in the wells to rise 800 or more feet all of a sudden and spill out the top when there's no indication of rising fluid in the wells?
The possibility of that is there. And the regulation says the casing needs to be equipped where it will not cause pollution. So that is my answer.
Chair French, if you'll engage me one more question, I just like to ask Mr. Dooling one more on the subject. Mr. Dooling, have you seen a situation previously where wells that had no indication of rising fluid all of a sudden rose 800 plus feet and spilled out the top? Have you seen that before?
Yes, I have.
Which wells?
That information is not in front of me. I thought we were coming to the hearing today for the docket 3169, so I do not have that. But in different instances, we have had problems with that because the fluid level that was reported was either reported correctly and the flood and the pressure of the field caused that, or other things have caused that. And we work with those situations when they occur. But you asked me if I've seen it, and yes, we have had wells that began flowing that had fluid levels, that was fairly low. Now, whether those were reported correctly, I cannot answer to that. But my answer is yes, that it has happened in the past.
I'll move on. Mr. Dooling, let's talk about when you knew about the 3030 case penalty order. Sharing my screen, I'm showing you what's been marked as.
You're going to need to zoom into that one quite a bit. That's better.
Mr. Dooling, can you read that?
Yes, sir.
Okay. I'm showing you what's been marked as Exhibit PDX1. Do you see your name and email address in the recipient section of this email?
Yes, sir.
Is it fair to say you received this email?
Objection. It's the relevance with this document.
A part of the argument that operator is trying to put forth is that staff's pattern of behavior is arbitrary and capricious. This goes to when Mr. Dooling knew about certain events, including the entry of the 3030 penalty order and the TA application that was submitted in August. Operator believes it will indicate arbitrary and capricious conduct.
I'm not sure I understand the relevance yet, but I will give you a few questions to help establish that.
Thank you, Chair French. Mr. Dooling, is this a true and accurate depiction of the email that you received?
I would say yes.
Okay. What is the date of this email?
It appears this email was sent August 5th of 2022.
And this is a consent agenda docket for what upcoming date?
Says it consent agenda for Tuesday, August the 9th of 2022.
Is the 3030 penalty order listed on that date? Or on this email, I should say.
It appears to be, yes.
So you knew at least as early as August 5th, 2022 that the penalty order in docket 3030 was going to be entered soon. Is that correct?
Objection. I'm going to renew my objection for relevance. I don't see how a closed docket is relevant to the present proceeding.
Chair French, if I may, this goes to Mr. Dooling's knowledge of when certain actions were taken. Where operator intends to show that this is consistent and the timeline matches up with when the August 2020 or the August TA application was submitted, and the timeline between when Mr. Dooling knew about it and when the penalty order was entered is relevant to an arbitrary and capricious position.
I think you're going to have to be a little more blunt with me.
Okay. Operator intends to show that Mr. Dooling knew about the upcoming 3030 penalty order before it was entered, and Mr. Dooling also knew that Patrick Development had resubmitted the August TA application correcting the issue before the penalty order was issued, and Mr. Dooling still didn't do anything to stop the penalty order or assist with operator and staying any punitive damages or any punishment despite operator trying to comply.
I mean, if an operator's passed the deadline already, I don't see how that's relevant really to this proceeding.
Chair French, I would say that this goes to a pattern of arbitrary and capricious conduct. This is but one part of it.
I mean, I would allow a few questions on this, but Mr. Ely, I'm generally inclined to find this does not have any relevance to sort of the legal question in front of us today.
Okay.
If you could promise me it's less than 5 minutes, I'd let you go ahead. But if you can't make me that promise, then I think I'm going to sustain the objection.
Okay. I can promise I will speed it up, Chair French.
If you can be very brief, then
Okay.
I'll give you a little bit of leash.
Stop my share and do it this way. Mr. Dooling, did you know about the 30-30 penalty order on August 5th?
I knew that it was going to be put on the consent agenda in front of the commissioners from that email, yes.
Did you know that operator resubmitted the TA application also on August 5th?
There's a possibility that I might have known that. I'd have to go back and look. I mean, I think I know where you're going, and the deadline was June 25th of 2022 to correct the denied TA application. So that, the penalty probably went in sometime after the 1st of July, a penalty recommendation, because he did not meet the first deadline that was given to him. So that even if the second TA come in on August 5th, which I'm not doubting that's the date you said he resubmitted, it's August 5th is severely past the 6/25/2022 deadline that was set for in the notice of violation letter that was sent to him.
Mr. Dooling, I'll just try to be quick with this. Did you know about the resubmitted August TA application prior to the penalty order being entered?
I would have to go back and look at when they were received. I mean, it says that there was a TA application come in on August 5th. Now, whether it came in before I got the email, I mean, I'm sitting on the stand, I don't want to lie to you. So I do not know when the TA came in and when the email from Paula come in saying it was going through to the consent agenda.
Mr. Dooling, I'm showing you what's been marked as Exhibit PDX2.
Okay.
You'll need to zoom in.
I'm sorry, Chair French.
You'll need to zoom in, please.
Mr. Dooling, I'm showing you what's been marked as Exhibit PDX2.
Okay.
Is this dated prior to the August 8th penalty order?
It says, I got an email on August 8th saying that they had resubmitted TAs.
Okay. And Mr. Dooling, you're the recipient of this email, or a copied recipient?
I was CC'd on this, yes.
I'd like to admit this into evidence. Operators Exhibit PDX2.
Any objection?
No objection necessarily. I mean, I still don't see how it's relevant to the current proceeding or shows any arbitrary or capricious behavior, but beyond that, the commission wants to allow it. I mean, it's a commission record, so.
We'll admit it and give it the weight it's due.
Mr. Dooling, did you undertake any action prior to that 30-30 penalty order in light of receiving the renewed TA application before the penalty order was entered?
No, sir. The deadline was already passed, so I mean, there wouldn't have been no reason for me to go any further than that. They were still out of compliance, but the deadline was already passed.
Mr. Dooling, you previously stated that the TA application for the second August set was denied on August 16th, 2022. Is that correct?
I'm going to say that's correct. You could bring that exhibit back up and we could say for sure that it was August 16th, but that date does seem familiar to me. I mean, I agree that it probably is August 16th is when it was the second set were denied.
Okay. I'll just note that we've already reviewed that exhibit. That was Operator's Exhibit 2C, and that testimony is already in the record. Mr. Dooling, I'm showing you what's been marked as Operator's Exhibit 1 is attached to Carrie Patrick's pre-filed testimony. Is this the penalty order in the 3030 docket?
Yes, it appears to be.
When was this penalty order entered?
Says it was, looks like entered on August the 9th of 2022.
I'm going to bring your attention to ordering clause C. The gist of that is about fluid levels, isn't it, Mr. Dooling?
Yes, it talks about fluid levels, also talks about testing the well if we find that possibly needs to be done. But the gist of it, yes, you're correct.
I'm going to go down to what's attached as Exhibit A to that penalty order. What was the reason given for the denial as it was attached to the penalty order entered on August 9th, 2022?
On that denial, it was for a current fluid level.
An operator had already submitted TA applications providing a current fluid level 4 days prior, correct?
I would have to look exactly. I believe that's correct, but it was way past the original deadline of June 25th of 2022.
Is there any portion of this 3030 penalty order that references a denial for caps or swedges? And I can scroll up if you would like to look at other portions of it.
I would like to look at all of it. Yes, I'm assuming the answer is going to be that is the only one because the operator we did not have another denied TA on that well until August, what did you say, 16th of 2022? And that's when it was also denied because the well was not shut in properly with surface control. So under this order here, that would be the only denied CP 111 that would be on this penalty order.
That's sufficient for my purposes. I'm going to stop that. Changing gears a little bit here. Mr. Dooling, I'm showing you the shut-in order in this docket. I'm going to scroll down to Exhibit A of that shut-in order. Can you see that?
Yes.
Is this the notice of suspension letter that was purportedly sent out to Patrick Development on November 7th, 2022?
I'm going to assume it is, yes. I mean, it looks like it come from the legal department, so this questioning might be better asked for a later subject. But
well,
it appears to be, yes, sir.
If you don't mind, I'll ask what you know about this, and then if I need to ask Mr. Kimbrell, I can.
Okay.
Who on staff prepared this letter?
I cannot answer that. I do not know. It come from the legal department.
Do you know who sent the letter?
I'm assuming the legal department.
Do you know with absolute certainty that this letter was sent in the mail with proper postage addressed to operator?
No, sir.
Objection outside the scope of his testimony.
Chair
I'll
French,
s-
I would
I'll
just say
sus-
that
I'm
the
gonna
issue in
sus-
this case is notice.
Well, I'm gonna sustain it because I don't think we've established that service was within Mr. Dooling's personal responsibilities.
Okay. Mr. Dooling, in this letter that was purportedly sent to operator, staff states a deadline of November 17th, 2022. What is the significance of that date?
The significance of that date is I believe, let me read so I'm not mistaken. Okay, at any time after November 17th, all operations need to be shut in because the license had been suspended. And it says anytime after November 17th, if operations are still going, that there can be an additional penalty.
Mr.
So
Dooling,
that-
staff also states that it would recommend a penalty. What is the amount of that penalty that was suggested in the letter?
It appears in this letter, it says 10,000.
The value of the penalty that was ultimately imposed in this proceeding was 25,000, was it not?
That's what the order says, yes.
Mr. Dooling, let's talk about what staff did after that November 17th deadline. Mr. Dooling, I'm showing you what's been marked as Exhibit PDX 3. This appears to be a meeting notice. Do you see your name in the list of required attendees?
Yes,
Is it fair to say that you received this notice?
it's fair because I'm the one that put it on the calendar, yes.
Is this a fair and accurate notice of that meeting then?
It's a reminder meeting, yes.
I would like to offer PDX 3 into evidence.
No objections.
It's admitted.
Thank you, Chair French. Mr. Dooling, did you attend this meeting?
Well, it really wasn't a meeting. It's a calendar with a list of events of when things need to be checked on. So the reason my name is a required attendee is because I'm the one that made the calendar entry and I track those calendar entries. So that's the reason my name was on it.
So there wasn't actually a meeting that was conducted on November 21st?
On November 21st, that was
Yes.
the date. That was the date that the November 21st date is the date that was staff, either Mr. Thompson, Mr. Hermick, or Mr. Carswell was supposed to just check to make sure everything was shut in and all production had ceased, because that was the date after the 17th November 17th deadline.
Okay, so Mr. Dooling, help me understand this. Correct me if I'm misinterpreting things. I just want to make sure I understand. So there was not an actual meeting that was conducted on November 21st. This is just a calendar reminder for someone on staff to go check leases. Is that correct?
That is correct. That November 21st deadline is a reminder that at least check needed to be checked.
Okay. Mr. Dooling, are you aware that November 17th, 2022 was a Thursday?
I'm not going to disagree. I mean, without going back and looking at a calendar from over a year ago, I do not know what day that is.
Let me do this a different way. I would ask that the commission take judicial notice that November 17th, 2022 was a Thursday, and that November 21st, 2022 was a Monday.
Sorry, I'm gonna look at my own calendar real quick. Which
If I
days
counted
did you
wrong,
say?
please, Chair French, let me know.
which days did you say?
November 17th, 2022, I believe that was a Thursday. And November 21st, 2022, I believe that was a Monday.
That's what it says on my calendar. We will I suppose we will take notice of the calendar, and those are dates that are readily identifiable. We won't say definitively that those were the dates, but we will take notice of the calendar.
Thank you, Chair French. That's sufficient for my purposes. Mr. Dooling, so staff decided to send somebody out to check operators' leases 2 business days after the deadline that it had given operators. Is that correct?
I would have to look when staff went out. It's in the field report, but the reason those dates were set in November 7th, I believe, is when that letter went out with that November 17th deadline. So that's where those dates come from. Anytime after November 17th, operations should be shut in, sealed, not operating. So I chose the 21st because it's after the 17th. So, I mean, I don't know if that answers your question or not, but that's where those dates come from, is because I have to track any compliance letter that comes through, and that's the best way that I can do to track it.
Mr. Dooling, I'm showing you what's been marked as PDX4. Do you see your name in the copied recipient section of this email?
Yes, sir.
Fair to say that you received this email.
Fair to say I did.
Attached to this email is a lease inspection. Is that related to the allegations against operator in this proceeding? Is that correct?
That is correct.
At this time, I would offer PDX4 into evidence.
It's admitted.
Thank you, Chair French. Mr. Dooling, what is the date of this inspection?
The date of this inspection was done on November 21st of 2022.
Scroll down to the first photo. What lease is this taken from?
This one was taken from the gray lease.
And that's one of operator's leases?
That is correct.
And the date this photo was taken was also November 21st, 2022. Is that correct?
That is correct.
What time was this photo taken?
Says it was taken around 1:46 p.m.
Okay. So, Mr. Dooling, is it fair to say that 2 business days after the deadline that staff provided of November 17th, 2022, staff had someone on operators' leases inspecting them for potential operation on a suspended license? Is that correct?
Well, it was actually, I mean, you said 2 days, the 17th to the 21st would be 4 days, but.
Two business days, Mr. Dooling.
Oh, 2 business, I apologize. I did not hear that. Yeah, I would go with that. Yeah.
Okay. And this is approximately 5 hours after your meeting notice. Is that correct?
I'm going to say that's correct. Yeah, I didn't look at the actual time I put that calendar in there, but it would have been within that. Yeah.
2 business days is a pretty quick turnaround between a deadline and having boots on the ground on a lease, wouldn't you say, Mr. Dooling?
Yeah, it just depends on what other activities are going on within the district. I mean, if he wouldn't have been able to get there on the 21st, 2 more days wouldn't have hurt anything.
During the period between November 7th, 2022, and when the shut-in order in this proceeding was entered on December 29th, 2022, did you ever reach out to operator about operating on a suspended license?
I do not recall, no.
Did you reach out to operator at all during that time period?
Me personally, I do not recall that I did. No, I do not know if any field staff had talked to him during that time frame or not.
After the shut-in order was entered on December 29, 2022, did you seal operators' wells?
We did seal their leases. It was, I believe, I'd have to go back. I believe it was January 4th, maybe. Um, I believe it's in my testimony or rebuttal. But yes, we did seal the operators' leases.
When you went out to seal operators' leases, did you meet up with operators Pumper, James Hasselroad?
Hackleroyd, yes.
If I'm mispronouncing that, I apologize.
And
Hackleroad?
I should probably, I might be, I've worked with James several years and he's always said Hackleroyd is how you pronounced it, but maybe I mispronounce it also.
I'll just call him James. Is that fair, Mr.
Okay,
Dueling?
I know who you're talking about.
Okay. Mr. Dueling, I want to pull up your pre-filed testimony here. Give me a moment to make sure my Zoom is correct. Mr. Dueling, I'm trying to show you what has been marked as your pre-filed rebuttal testimony that was submitted on November 3rd, 2023. Can you see that?
Yes, sir.
Okay, I'm going to go down to page 6. And I want to direct your attention to
Mr. Ely, why don't you zoom in just a little bit? If anybody doesn't have this in front of them separately, it's pretty small on the Zoom.
is that legible, Chair French?
It is for me, if it
Okay.
is for others, but if anybody else can't see it, just speak up.
Okay. Mr. Dueling, I want to direct your attention to the question beginning on page 6, line 4, and your response beginning at line 8. Is that still your testimony today?
Yes, sir.
Okay, I'm going to keep going down here. Beginning at page 6, line 18, and your response that begins on page 6, line 22, and carries over to page 7, line 7. And I'll try to get as much of that on the screen as I can. And if you need me to scroll down, let me know. Is that still your testimony today?
Yes, sir.
Including this portion down here?
Which portion?
I just scrolled down to show the rest of your response, the whole response. That's still your testimony today?
Yes, it is.
Okay. Mr. Dueling, am I understanding your testimony correctly that you went all the way out to operators' leases on January 4th, 2023, including the Bodley Pringle lease and the Johnson lease for the purposes of sealing operators' wells, but you didn't look at the Bodley Pringle 7 or Johnson 7 wells to see if they had caps or swedges on them? Is that correct?
That is correct. Yeah, we were there to seal the electric meters to make sure that we sealed all lease activity. I didn't go to each individual well or any wells. We went to the electric meters so we could seal the leases to guarantee no more operations.
Do sealing the electric meters, is that an effective way to seal all of the wells on a lease?
It's about the most effective way that I know of to seal leases, yes.
Does commission staff, when they seal leases, do they also go out to leases that don't, or wells that don't have electricity to them and put zip ties or anything like that on them?
When we go to seal leases, we seal them all usually the same way. We seal all the electric meters on the lease, and that's how we seal them. We do not go to each individual well unless we are noted to do so by higher ups.
So, Mr. Dooling, you left the Chanute office on January 4th. And I apologize. The sun is beaming into my face. Give me just a moment here. I apologize about that. I was getting blinded.
No worries. I noticed and I was worried about you.
Mr. Dooling, so let me understand, you left the Chanute office on January 4th and you drove all the way out to all of operators' leases and you didn't go the last few feet to the wells that you were sealing. You just stopped at the electric meter. Is that correct?
We were there to seal leases, not inspect wells.
Okay.
That was the purpose of the event trip to the leases, was to seal the leases.
If you were sealing leases because two specific wells did not have caps or swedges on them, why didn't you go the last few feet to look at those specific wells?
Because when we met Mr. Hackleroyd on site at the first lease, because we contacted him saying that I believe tried to contact Mr. Patrick, but James actually called me that morning. And when we were there, we did not go to any wells because Mr. Hackleroyd and I had visited about why we had to do this. And I said, it's because we still have two wells that are out of compliance and nothing had been done to them. And we even discussed what needed to be done because Mr. Hackleroyd said that they had not done anything. So why would I spend extra time to go inspect any other things when I'm there to seal the whole leases when he had noted that nothing had been done and wanted to know what needed to be done because he hadn't had any guidance from Mr. Patrick.
Okay. I'm going to share my screen here a second. Mr. Dooling, I'm showing you what has been attached to Mr. Kimbrell's pre-filed testimony as Exhibit TK7. Mr. Dooling, what is the date of this email?
It looks like December 29th.
And that's prior to you
2022.
going out there on January 4th, correct?
That would be correct, yeah.
Who is this email from?
Looks like that email is from Kerry Patrick.
And it's to Mr. Kimbrell.
That is correct.
Mr. Dooling, can you read the first paragraph in the body of that email?
Okay.
Can you read it out loud for the record, please?
Oh, sorry about that. As per complaint and our conservation today, two caps on the wells that are the subject to this penalty order have been placed, so it has been remediated.
Mr. Dooling, does it appear that Mr. Patrick informed commission staff on December 29th, prior to you going out there on January 4th, that the caps were on the wells and that the wells have been remediated?
I'm going to assume that, yes, it doesn't say, it just says put two caps on wells. I mean, I'm not going to testify to say that, I mean, if he would have, I don't see the Johnson or Bodley, but it says two caps on the wells.
Did Mr. Kimbrell inform District 3 staff of the substance of this email, that caps or swedges have been placed on the wells on December 29th?
Objection. For relevance, at this point, the shut-in order would have already been issued and staff would have already found operator operating on a suspended license. So I'm not sure how this testimony is relevant at this point in time.
Chair French, if I may, this goes to arbitrary and capricious conduct. Mr. Dooling has testified that Mr. Hassleroad told him that nothing had been done to the wells on January 4th. We have an email that indicates that something had already been done to the wells on December 29th. And I would just like to know whether or not Mr. Kimbrell communicated this to Mr. Dooling.
I'm going to overrule for now. Mr. Dooling can answer to the extent he has knowledge.
Mr. Dooling, did Mr. Kimbrell inform District 3 staff of the substance of this email, that the caps or swedges had been placed on the wells on December 29th?
I do not recall. That's been a long time ago, and I do not recall.
Mr. Dooling, for the sake of the record, I'm showing you what's been marked as Exhibit PDX 7. I intend to admit this into evidence via Mr. Kimbrell. Mr. Dooling, what is the date of this email?
It appears this email was sent January 5th of 2023.
Mr.
Where's the
Ely,
email
can
from?
you zoom in just a bit on this one?
My apologies, Chair French.
Thanks.
Mr. Dooling, who is this email from?
Carrie Patrick,
Who's this email to?
Tristan Kimbrell.
So this email was sent from Mr. Patrick to Mr. Kimbrell the day after you went out to seal the leases, correct?
That's correct. It's what it appears, yes.
Okay. Mr. Dooling, I'm going to read portions of this email, and if I'm reading it incorrectly, please correct me. I'm going to start with Roman numeral I. As per your email, all of the requirements for these two TA applications have been met and so submitted on COLAR by Patrick Development on the 30th to the commission, but for some unknown reason, they have not been approved. I'm going to go down a little bit further here. On the 3rd, I received a phone message from KCC District Number 3 staff, and as I understood the voice message, its purpose due to your email was to visually determine whether or not, in fact, I had put the caps on these two wells. According to my head pumper, James, the KCC District Number 3 staff came out yesterday to the leases and saw that they were not pumping as I so committed to you, plus they saw the swedges or caps were on the above two wells too. Mr. Dooling, did I read that correctly?
I believe so, yes.
Okay. I want to focus on that last part. Where the email states, according to my head pumper, James, do you interpret that to be the same James, who I don't know how to pronounce his last name, Hackleroad?
I assume, yes, that's the only James Hackleroyd that has worked for Mr. Patrick for several years. So I'm assuming that is the James, yes.
And you were with that same James the day before, correct?
No, sir. Well, what day fit for? Yes, the day before. Yes, on the 4th.
Okay. KCC District Number 3 staff came out yesterday to the leases. Do you interpret that to include yourself?
I'm going to interpret that, yes, because I was there on the 4th.
And then the statement in the email, and saw that they were not pumping as I so committed to you, plus they saw the swedges or caps were on the above wells too. Does this email make it sound like James told Carrie Patrick that you saw the swedges and the caps on the Bodley Pringle 7 and Johnson 7 wells on January 4th?
Objection, calls for speculation.
Chair French,
I don't know what opinion Mr. Dooling can offer. I mean, he can read the email as well as we all can. Mr. Ely, maybe restate your question.
actually, Chair French, I think what I'm going to do is I'm just going to let the documents speak for themselves. I believe this will be admitted into evidence when I get Mr. Kimbrell. I think I have what I need from this.
Okay.
As far as that goes. One last question on this one, though. Mr. Dooling, does this email also indicate that operators submitted the TA applications for the wells on December 30th?
Repeat that last part. December what?
Does the email indicate that operators submitted a new set of TA applications for the wells on December 30th? And I'll direct your attention to the portion of the email that starts with the Roman numeral I.
That's what the email says.
Okay.
I would have to, I mean, I would have to go back and look to see when the operator. I'm not saying it wasn't the 30th, but I'm not saying it was the 30th. I'd have to go back and see when the TAs were actually received before I would say, yes, that's correct. But
Do you know when the TAs were received?
when they were received, I'm pretty confident that the actual TA was received through Kohler when he submitted it on January 4th. It was January 4th or 5th. I'd have to go back and look, but I'm pretty sure it was not December 30th.
Okay. Do you have any evidence that supports that date?
Not with me. I'd have to look that up.
Okay. Well, Mr. Dooling, Mr. Patrick has indicated that the TA applications were submitted on December 30th. If you had already had the TA applications, why didn't you just go inspect the wells when you were out there sealing the leases?
Again, I do not believe that date is correct. When we went out on January 4th, we were instructed to seal the leases, so that's why I was there.
Mr. Dooling, if staff had already received notice that the issues were resolved on December 29th, and I'm going to go back and reference that email on December 29th from Mr. Patrick to Mr. Kimbrell, where Mr. Patrick purported to have fixed the issues, why didn't you go out and inspect the wells while you were there sealing the leases?
Again, I do not believe that TA was submitted before then. We had no record that the TA had been submitted. I was there on January 4th to seal leases because that's what I was told to do by my supervisor. We weren't there to inspect any wells. We were there to seal the leases.
And so, Mr. Dooling, let me understand it. Your testimony is that you would have looked at the wells, but James Hasselroad had told you nothing had been done to fix them. Is that correct?
Mr. Hackleroyd and I had a conversation before we sealed any electric meters. I told him why I was there, and he said he had talked to Mr. Patrick and knew that I was coming, and he wanted to know why it got this far. And I said, as far as I know, the two wells that were denied CP 111 applications had never gotten taken care of, and then this docket came after that. I asked him, I said, because he goes, what do we have to do to get this so we can turn these leases back on? And he says, do we have to plug the wells? I said, not necessarily. I said, I'd have to go back and look at the denied CP 111s as long as they're within the 10-year shut-in time frame and there was no other problems, that he either had to plug them, put them into production, or get approval of temporary abandonment. And that's when Mr. Hackleroyd said, well, we probably ought to just plug them. He said, their wells aren't no good. And I said, well, that's the opportunity. The operator has three options. That's the three options we have. And he said he would contact Mr. Patrick and try to get something scheduled so they could get this resolved. And that was on January 4th when I was there with Mr. Hackleroyd. So no, I did not go to the two wells because he'd said that nothing had been done. So there was no use to me go to inspect those two wells anyhow.
I'm going to share my screen here. And I expect a little pushback from Mr. Marsh on this one.
Yeah, I'd object to this being offered or proffered. There's no there's no foundation for it. So
okay. I would say I've raised an issue with these specific portions of Mr. Dooling's testimony previously. My objection was overruled. This is being brought specifically for the purposes of impeachment. Mr. Dooling is testifying as to what Mr. Hackleroyd said. I have a signed and sworn affidavit from James Hackleroyd specifically addressing the exact same portions of Mr. Dooling's testimony. I would say that if we're going to let hearsay evidence in on one side, we got to let it in on the other.
Well, in contrast to that, though, I'd say the difference is you've had the opportunity to cross-examine Mr. Dooling and, try to make your points. But as far as I can tell, Mr. Hackleroyd is not here. He's not available for cross-examination. It's an out-of-court statement. There's no foundation laid. I mean, there's lots of issues with this document being presented right now.
I would point out that we don't have a jury here. We have no one to confuse. The commission is completely capable of evaluating this affidavit and giving it the weight that it deserves on its own.
Yep. All right. I can I can tell you guys where I'm going to go from here. I am going to allow you to continue with it as long as the examination of this document is not too long. I agree it's for impeachment purposes. And if you want to ask questions of Mr. Dooling about this document, that's fine. I will also allow you to admit it, and we will give it the weight that it's due, given the fact that we're going to have to assess credibility of this document versus Mr. Dooling, and we will consider the fact that Mr. Dooling was available for cross-examination, and the creator of this document was not. I think that's fair, but I will allow you to admit this exhibit, and I will allow you to ask questions about it.
Thank you, Chair French. At this time, I would ask, this has been marked, by the way, as Operator's Exhibit PDX 6. I would ask that PDX 6 be admitted into evidence.
Mr. Marsh, we will note your objections. I think you listed a few, and we will note those for the record. But as I said, we'll go ahead and admit this for the purpose of impeachment evidence and allow some cross-examination on it.
Thank you, Chair French. Mr. Dooling, what date does Mr. Hackleroyd state in this affidavit that the swedges were put on the Bodley Pringle 7 and Johnson 7 wells?
I will have to read through this because I do not know. Could you blow that up just a hair?
I can. And I apologize if it's too small to read.
I'm just getting bad eyes.
Maybe zoom in one more time, Mr. Ely. It's still pretty small on my screen. Oh, that might be too much. I don't want to let Mr. Dooling direct you as to what he needs.
I think that right there will fulfill my eyes to be able to adjust better.
Thank you, Mr. Dooling. I'll direct your attention to paragraph number 2.
Okay. You want me to read this out loud? Is that what you asked me to do?
I just want to know what date I'll say James, what date did James indicate he put the swedges on the wells?
On this document, James said he placed swedges on December 29th of 2022.
Does James also state when he turned off the electricity to the leases?
It states electricity was still turned off when Mr. Trumpsess and myself were sealing leases on January 4th. I do not see when it says he did shut it off. Do you see that? Am I in the wrong paragraph? I was in paragraph 3, Mr. Ely.
If I may, if you just want to read the first portion of paragraph 3 to the comma, I think that will answer our question.
When I went to the Bodley Pringle lease and the Johnson lease that day.
And do you understand that to be December 29th, 2022?
I do not know what he's trying to state there. I have no idea what day he's talking about.
Okay, I'll just let the document speak for itself. In paragraph 4, does James indicate that he observed you visually inspecting the swedges on the Bodley Pringle 7 and Johnson 7 wells?
Well, that's what that statement says right there. I disagree with that statement.
Okay. And then paragraphs 5, 6, and 7, correct me if I'm wrong, but the affidavit essentially disputes your previous statements in your pre-filed testimony. Is that correct?
I'm sorry, 5, 6, and 7?
5, 6, and 7, that cites portions of your pre-filed testimony and disputes them. Is that correct?
That's what those statements say, which I will also disagree with.
Mr. Dooling, I've scrolled down. Does this document appear to be signed and sworn to by James?
His signature, I mean, his name signed there, yes. I do not know if he was the one that signed it or not.
Move on. Mr. Dooling, I'm going to go back to your pre-filed rebuttal testimony. Starting at page 6, line 23, you state, the reason it took 15 days to reinstate operator's license is because staff needed to perform a field inspection to make sure operator had appropriately implemented surface control at the Bodley Pringle 7 and Johnson 7 wells prior to staff approving the TA applications for those wells. Did you say that?
That's correct.
So the reason for the field inspection after January 4th, 2023 was to make sure that the caps or swedges were on the wells. Is that correct?
That is correct.
I share my screen again. For the sake of the record, I'm showing you what's been marked as Exhibit PDX 9. And I intend to admit this into evidence via Mr. Kimbrell. I'm going to scroll down. To the email dated Thursday, January 12th, 2023 at 1:54 p.m. Mr. Dooling, can you see that email on my screen?
I can see part of it, yes. I mean,
I'm trying to encompass as much of it as I can here. Can you see who this email is to?
it looks like it's to Mr. Patrick.
Do you see who this email is from?
Yeah, Tristan Kimbrell.
Can you please read the first paragraph of the email out loud for the record, please, stating with "I have been in contact"?
Objection. I believe this email is outside the scope of Mr. Dooling's testimony.
Chair French, I am introducing this for impeachment purposes. Mr. Dooling has testified that the reason for the delay on the inspection was to make sure that there was surface control. This contradicts that. I think that it is relevant to Mr. Dooling's credibility.
Explain to me just a little further how this email between Mr. Kimbrell and Mr. Patrick is relevant to Mr. Dooling's testimony.
Mr. Dooling had just testified that the reason it took 15 days to reinstate operator's license was because there was a need to perform a field inspection to make sure operator had appropriately implemented surface control. We've already discussed the surface control and whether or not Mr. Dooling saw it on the wells when he went out there. This email is in regards to the exact same inspection that Mr. Dooling just testified for, but the reason provided by Mr. Kimbrell is different than the reason provided by Mr. Dooling. I'm trying to figure out what the reason for the inspection was.
I mean, there's no indication that, I mean, it's possible that Mr. Kimbrell consulted with Mr. Dooling, but there's nothing that says, oh, I spoke with district staff and this is what they said. So I don't get how this is impeachment material.
Yeah, I'm struggling with what Mr. Dooling can do with this document besides reading it.
Let me continue. This document purports that the reason for the inspection was a concern regarding fluid levels. I would like to address whether or not that was a reason. And if it was, then Mr. Dooling can testify as to whether or not that inspection looked at the fluid levels and what the concern regarding fluid levels would have been.
Yeah, I mean, I think you can go ahead and ask a couple questions. Just ask Mr. Dooling whether this changes any of his testimony.
Mr. Dooling, what is the reason Mr. Kimbrell gives in the email for the inspection?
Could you repeat that again? I got kind of lost. I'm sorry.
What is the reason Mr. Kimbrell provides in this email for the inspection after January 4th?
The email says I have been in contact with staff and I believe there is concern regarding the fluid levels reported in the TA applications. I believe it is still staff's intention to perform field inspections of the wells. It doesn't say why we were going to do the field the field inspections need to be done because they were denied because lack of surface control. That's the reason staff had to go reinvestigate the wells to make sure that adequate surface control had been applied to the wells before the newly TA applications could be approved, the ones that were, I'm pretty sure, sent in January 4th.
Mr. Dooling, was there a concern about the fluid levels? Was that a reason for inspecting the wells after January 4th?
Not that I'm aware of. I mean, we would have been inspecting them for the surface control.
So Mr. Kimbrell's statement in this email is incorrect then?
I do not know. I do not know what the whole, I mean, you just scrolled through about 15 emails there. I didn't see this email. I do not know. There's always an issue. I mean, when you approve a TA application, there's not just one reason to approve or deny an application. Everything has to be correct and it has to fall within the regulations set forth by the commission. You just asked me if we had to go for surface control, and yes, that was the reason they were denied the last time was for surface control. They were denied previously for fluid levels, but not the second time.
I guess, Mr. Dooling, I guess I'm just confused. Was there a concern with the fluid levels in early January of 2023 at the Bodley Pringle 7 and the Johnson 7 wells?
Objection. Hasn't this been asked and answered?
If it has, I apologize. I guess Mr. Dooling's answer, I'm still confused by it personally. I don't know if District 3 staff acknowledges the same concern that Mr. Kimbrell did in this email, and I would just like the answer to that.
I'm inclined to say it has been asked and answered, but Mr. Dooling, why don't you give one final answer to whether you share that concern as well?
And I apologize. Could you repeat that concern, Mr. Ely, so I'm speaking on something correctly? Because I'm a little bit confused too.
Yes.
To be honest with you.
Let me just ask this in a yes or no question. Yes or
Okay.
no? Did District 3 staff have concerns about the fluid levels at the Bodley Pringle 7 and the Johnson 7 wells in January of 2023?
I do not believe so.
Okay. Mr. Dooling, when was the inspection ultimately conducted in January of 2023, which confirmed the caps or swedges on the Bodley Pringle 7 and Johnson 7 wells?
There should be a field report in one of the testimonies. I believe that date was January 17th, but I'd like to find that field report. And I don't remember if it was in my rebuttal or Mr. Patrick's. Somewhere there should have been a field report in that had the exact date when we were out there to inspect, but I believe it was January 17th because that was when the applications were approved for temporary abandonment status.
Mr. Dooling, who conducted that inspection on January 17th?
That would have been ECRS Ryan Trumpsess out of the District 3 office.
What did District 3 staff check when it went out there on December 17th or January 17th? I apologize.
They went to make sure there was proper surface control applied to the casing so the well was shut in.
Were there any other wells or leases that were inspected on that date other than the Bodley Pringle 7 and the Johnson 7?
Without going back and looking at calendar, I do not know. We keep a daily activity of what all staff does, but those two wells were the only ones that I'm aware of that was inspected on Mr. Patrick's leases that day.
And if I'm incorrect in the statement I'm about to make, I expect Mr. Marsh to correct me very quickly. Are you aware that operator has not been provided a inspection or field report for January 17th, 2023?
I'm not aware. No,
Was a field inspection report created?
I do not know. I would assume there would be, but it might be just the CP1 applications that were approved. If there was no reason for denial of them, field staff might not have done a field report. Usually field report documents problems that are found with the wells. Since we approved the TA status for those two wells on January 17th, there might have been no reason to do a field report showing that because the CP1 applications were approved. So we know that they were approved, that the wells had been shut in correctly.
Mr. Dooling, do you have any evidence that you can present before the commission that corroborates the statement that a field inspection was conducted on January 17th?
Could you rephrase that? I don't know what that one word means. Sorry.
Let me rephrase. Do you have any evidence that confirms your statement that a field inspection was conducted on January 17, 2023?
No, nothing other than the approved temporary abandonment applications that was submitted by Patrick Development.
Can the applications be approved without a field report?
Yes.
Were they approved without a field report?
Says they were. I mean, it says they were approved on
So,
January 17th, 2023.
Mr. Dooling, do we know for sure that an inspection of Patrick Development's leases, specifically the Bodley Pringle 7 and the Johnson 7, do we know for sure that there were boots on the ground, that they went out to investigate that on January 17, 2023, or did staff just administratively approve the TA application, unsuspend operator's license?
No, Mr. Trumpsess went to those two wells that day. I talked to him on the phone and he was actually headed there when I talked to him that morning because we keep a calendar and it shows what each staff member's doing that day. So I would have contacted Mr. Trumpsess to make sure that he was going out there, or we would have changed that date in case it went to further down the line.
So there would have been a calendar event like the meeting that we discussed earlier, correct?
It's not that was sent directly to those individuals because I requested a date on that deadline. We keep a daily log that shows, what different staff are doing, but it wouldn't have had an email reminder saying that, unless I actually sent Mr. Trumpsess an email reminder right then saying either confirm or deny. That's when that is made on that calendar.
Mr. Dooling, are you aware that operator was not provided in discovery any logs indicating that an inspection was conducted on January 17th?
I'm not, no.
Mr. Dooling, do you know when the seals were ultimately taken off of Patrick Development's wells?
Leave. Sorry, I'm looking for that so I don't mistake on a date.
Mr. Dooling, I might be able to assist you here.
I would appreciate that, sir.
Is that large enough for you to see it?
I believe so.
All right, Mr. Dooling, I'll just kind of run through this. Do you see your name and email in the recipient section of this email?
Yes,
Is this fair to say that this is an email that you received?
that is correct. Yes,
And this email discusses when the seals were taken off of Patrick Development's leases. Is that correct?
that is correct.
All right, I would ask that this is what has been marked as Exhibit PDX 5. Probably should have said that at the beginning. I would ask that this be admitted into evidence, please.
No objection.
It's admitted.
Thank you, Chair French. Mr. Dooling, based off this email, were the seals removed on January 19th and January 20th, 2022?
That is correct. All the leases in Woodson County were removed. It says on the 19th, and the one lease in Miami County was the next morning.
Mr. Dooling, I want to make sure I understand this timeline correctly. It took approximately 3 weeks after Mr. Patrick notified Mr. Kimbrell on December 29, 2022, that the caps or swedges were on the wells and that everything had been corrected. And subsequently to that, Patrick Development purports to have submitted its caller application on January 30th and has provided an email to that effect. Approximately 3 weeks after that date is when operator's license was unsuspended and the seals were removed. Is that correct?
You said January 30th. What date was that you?
I'm sorry,
confirmed
December
date?
30th is when the COLAR was emitted. So from December 29th and December 30th, it took approximately 3 weeks for staff to unsuspend operator's license and remove the seals from the wells. Is that correct?
Objection. What's the relevance here?
Chair French, this goes to arbitrary and capricious conduct. We've established that staff was able to get boots on the ground on the leases 2 business days after its deadline. And we also have evidence that indicates 3 weeks for it to get back out there to fix issues.
I mean, we're still talking about oh, sorry, Chair French.
It's all right. At this point, I'm going to sustain the objection. The dates speak for themselves. The parties can comment on it however they want, but I don't see much relevance in the question. So let's move forward.
Chair French, that's actually my last question. Mr. Dooling, I have no further questions for you.
Thank you,
All
sir.
Very good. Let's see. We've got a few minutes before I do want to try to break for lunch sometime fairly soon. But we do have a few minutes. So we've still got commissioner questions yet to go and potentially redirect if staff thinks it's necessary. Let me ask at this time, Commissioner Keither, do you have any questions for Mr. Dooling? Okay, and I actually do not have any questions either. So Mr. Marsh, do you have any redirect that you need to perform?
If I may, just a few questions, Chair French.
Go ahead.
Ryan, I know that Mr. Ely, excuse me, talked in depth about the 2033, words are hard today, apparently. It's Monday. The docket 23-3030 penalty order. Was there a field report attached to that penalty order?
I'm assuming there would be, yes. I would have to try to find that penalty order, but normally we would attach field reports for it that go forward for any penalty recommendations.
Okay.
Yes. You're talking about the 30-30
Yes.
penalty? Yes, there was a field report, actually 2 field reports, I believe, Mr. Marsh, attached to that penalty order.
Okay, I pulled up the penalty order or one of the field reports that's attached as Exhibit B to the 23-3030 penalty order. Mr. Dooling, what date was that field inspection conducted?
July 28th of 2022.
So that field inspection would have been done after the first set of TA applications were denied, correct?
Yes.
And in that field report, did staff note that there was no surface control on the 2 wells at issue?
Yes.
And I
It
guess
did.
this is for
That one's for the bodily Pringle number 7 only. There should be another field report for the Johnson.
okay. And there is no surface control on the Bodley Pringle number 7 well.
That is correct.
And then, like you said, there's a second field report for the Johnson 7 well. And is there any surface control implemented at that well?
No, sir. There's actually 1 inch hanging on a clamp on that well, and the 1 inch is also open. No surface control.
So would it be fair to say that the information that staff had changed from the date that the first TA application was denied?
Well, yeah, I mean, it changed, but I mean, usually when operators file CP1 applications, they understand that the wells need to be shut in. I mean, staff didn't realize that the operator submitted them and did not have the wells shut in with surface control until we did field inspections on the wells. So, I mean, that would have been the additional change of why the next application would have been denied, is we had already assumed that the operator would have had the wells shut in before he applied for temporary abandonment status.
I think you said CP1. Do you mean CP111 application?
Yes, CP111 temporary abandonment applications.
If there is no surface control at a well, could it cause pollution of fresh and usable water resources?
Yes, it can.
Does staff have the authority to deny TA applications in order to prevent the pollution of fresh and usable water?
Yes.
Now, operator's license was suspended on November 7th, 2022, correct?
Correct.
An operator was required to have its leases shut in by November 17th, 2022.
That is correct.
And was operators' leases shut in at the time that commission staff inspected the leases?
Repeat that. I'm a little confused by the
I
question.
guess, sorry. When did staff inspect operators' leases to ensure that they were properly shut in?
The wells or the leases?
Either.
I mean,
Well, the wells, so the operator's license was suspended on November 7th, 2022. When did staff inspect the wells or leases to ensure that they were properly shut in pursuant to that shut in or suspension?
We shut them in January 4th. We sealed all the leases on January 4th.
But when did staff inspect to see if they were operating under a suspended license or not?
Oh, I'd have to go back to that date. Sorry. November 21st of 2022 is when we inspected and found that there was operations going on the leases on November 21st of 2022.
And that was after operator's supposed to have all of its leases shut in, correct?
That's correct. They were supposed to be shut in and sealed on November 17th. Staff done the inspections on November 21st.
Is it common to reach out to operators regarding a suspended license?
I mean, no, I mean, they are notified when their license is suspended through Kohler and stuff, but at the district level, we usually do not reach out to them personally with a phone call or something saying your license has been suspended. Most of the time they'll call us and say, hey, my license is suspended. What's going on? And then we will have to investigate and then see why their license is suspended and then see what we can do to help them get it reinstated.
I know Mr. Ely asked you some questions about Exhibit PDX. I'm going to pull that up real quick, if I may. Mr. Dillon, can you see that exhibit?
Yeah.
And I know Mr. Ely asked you questions about the emails from Mr. Patrick to Mr. Kimbrell, correct?
That's correct.
Is there any email or documentation here that shows that Mr. Hackleroyd sent this information to Mr. Patrick?
Not that I'm aware of.
And I know he also attached an affidavit from Mr. Hackleroyd as Exhibit PDX-6. In regards to paragraphs 4 through 7 of that affidavit, do you believe that information that Mr. Hackleroyd has signed off on is accurate?
I'm here today under oath, and no, that information is not accurate.
Mr. Dooling, was Patrick Development treated any differently in this docket than any other operator would have been treated?
No, sir.
Thank you. I have no further questions.
All right. Thank you, Mr. Marsh. I think at this time we will conclude Mr. Dooling's testimony. Mr. Dooling, thank you for your testimony today. You may virtually step down.
Thank you.
Yes, thank you. We
Chair
are
French.
right. Go ahead, Mr. Ely.
May I request pointed recross, or is that denied by the commission?
Can you proffer to me exactly which topic needs additional clarification?
I would say the substance to what was referenced in the field reports and the 3030 penalty order and the statement at the end about being treated differently.
Well, at least on the first couple, we'll allow a little. Mr. Dooling, I'm going to call you back up to the stand. We're going to go through this technically. I'm going to make sure that I have re-sworn you because I think I technically let you off the stand. So if you would please,
French,
yeah.
is there, I don't want to kill any time today. I want to be done, but is there any chance we could break just a couple minutes to use the bathroom?
Absolutely. I always grant those. Let's take a 5-minute break and we'll come right back. We're
Thank
now in
you.
recess and off the record. All right, looks like we have everybody back. Commissioner Keither. All right, we are now out of recess and back on the record in our hearing. Mr. Dooling, I'm calling you back up to the stand, and if you will please raise your right hand, I'm going to swear you back in. Do you swear or affirm the testimony you give today is the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right. I think we were set to allow Mr. Ely just some brief recross. Go ahead, Mr. Ely.
Thank you, Chair French. I have pulled up, sure I have it correctly before me. The penalty order in docket 3030. Mr. Dooling, you were asked questions on redirect by Mr. Marsh about this, correct?
That's correct.
Okay. I'm going to scroll down to the field report that was attached to that. And you stated that the date of that field report was July 28th, 2022, correct?
That is correct.
And then through Mr. Marsh's questions, you pointed out that there are some statements about the surface control in this field report. Is that correct?
That's correct. Yes.
In between the period from July 28, 2022 to when the TA applications were denied on August 16th, 2022, did you communicate anything about the need for surface control to operator?
I'm going to say probably not at that time. No.
Other than the field report that is attached to this order, are you aware of any portion of this penalty order that references the need for surface control?
Objection outside the scope of redirect.
If I may, Chair French, Mr. Dooling was specifically asked about the existence of statements as to surface control on an attachment to this penalty order. I'm asking about surface control references in the penalty order. I feel like that's within the scope of redirect.
He was asked about the field report attached to the penalty order. He wasn't asked about the penalty order itself.
My statement remains the same.
Go ahead with your question.
Mr. Dooling, is there any portion of this penalty
Overrule the
order
objection.
that references
Sorry.
the need for
Just
surface
to be
control?
clear for the record, I'm overruling the objection. Go ahead with your question.
Thank you, Chair French. Mr. Dooling, is there any portion of this penalty order that references the need for surface control? And I can scroll down if you need me to.
Go ahead and scroll down, please, a little bit. That's good. Keep scrolling, please. Okay. And scroll down a little bit more. Okay, now would you repeat your question, please?
Is there any portion of the penalty order that references the need for surface control?
The only reference that order states that he's out of compliance with 82.3.111.
Does that
And being out of surface, or not having surface control is the reason for. So, I mean, it does not type out surface control anywhere in there, but yes, he was not in compliance with 82.3.111, and that was one of the reasons he was not in compliance with. So I don't know if that answers your question or not.
Mr. Dooling, you had testified that operator was treated the same as every other operator upon your redirect with Mr. Marsh. Is that correct?
Yeah, I mean, I wouldn't treat any other operator different. I mean, we sent the denial letter. He did not respond with the deadline of correcting the violation. So in return, I send a penalty recommendation on up. I would do the same thing if any other operator did not meet a deadline and didn't fulfill the obligation of a deadline.
What is the standard monetary penalty for operating on a suspended license?
That would probably be more of a legal question than me, but I believe the reg says.
Yeah, I would object. This is outside the scope of Mr. Dooling's testimony.
Let me rephrase. Mr. Dooling, are you aware that the penalty order issued in this case is a heightened penalty order?
Yeah, I was told that, yes.
Are most operators subject to heightened penalty orders?
Again, that would be a question that I do not know how to answer that.
I have no further questions.
All right, thank you, Mr. Ely. Since I did allow some recross, one more opportunity for commissioner questions. Mr. Keither, I don't have any. Mr. Marsh, any brief redirect?
No, thank you, Chair Branch.
All right. Then Mr. Dooling, for the second time, you may now step down. You're released.
Thank you, sir.
You're welcome. So let me pull up my outline here and see where we are. Looks like we still have one staff witness and then we will have operators witness, but we're at a good point for a lunch break right now. Why don't we take a, it's 12:10. Why don't we break until 1 o'clock and then we'll reconvene for our last two witnesses. Is that acceptable to both the parties?
Yes, Chair Branch.
Yes,
All
Chair.
right. So at this time, we are going to go into recess. We're off the record and taking a lunch break until 1 o'clock. See you all back at 1 o'clock. All right, do we have everybody back? I see Mr. Kimbrell, I see Mr. Myers, I see Mrs. Patrick, Commissioner Keither. Do we have Mr. Ely? All right, we've got Mr. Ely. I think we are good to go then.
Chair French, if I
Yep.
may,
Mhm.
it has just come to my attention that Mr. Patrick is currently en route to the emergency room. Mrs. Patrick has indicated that she can likely stay and finish the testimony in the hearing, but if the circumstance necessitates it, I would ask at that time, maybe we can evaluate an emergency continuance if we need to. But as of right now, until I know anything further, we can likely continue as planned.
Well, I certainly appreciate you letting me know. Would you have any interest in going ahead and going out of order for witnesses and having us bring Miss Patrick up and see if there are any questions for her? And then in that case, if we could address that, then she would be free at any time if she needs to depart to just go ahead and do that.
I don't have an objection to that.
No, I think we're fine. My best friend Larry, our neighbor, is gonna take Carrie. So if it gets a little wild here in the background, just I'll have it muted. So
All right.
yeah,
Well,
Carrie is not healthy right now. So we're just doing our best to keep him
all
in
right.
check.
Well, we'll do what we can to motor through then. All right. Well, let's see. We are all right. We are now back on the record and reconvening this hearing, and we are ready for staff's second witness, Mr. Kimbrell. Mr. Marsh, you may call your second witness.
Thank you, Chair French. Commission staff calls Tristan Kimbrell.
Good afternoon, Mr. Kimbrell. I'll have you please raise your right hand. Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, Mr. Marsh.
Thank you, Chair French. Can you please state your name for the record?
Tristan Kimbrell.
Mr. Kimbrell, by whom and in what capacity are you employed?
I'm employed by the KCC as a litigation counsel.
What is your work address?
266 North Main Street, Wichita, Kansas.
Are you the same Tristan Kimbrell who caused to be pre-filed in this docket rebuttal testimony consisting of 10 pages and 8 exhibits on November 3rd, 2023?
Yes.
Was this testimony created by you or at your direction?
Yes.
Now that you are under oath, do you have any corrections to make to your testimony?
No.
If I ask you the same questions contained in your testimony today, would your answers be the same?
Yes.
Do you swear the answers contained in your pre-filed testimony are true to the best of your knowledge?
Yes.
At this time, staff moves for the admission of Mr. Tristan Kimbrell's pre-filed direct testimony into the formal record. Or I guess it's not direct testimony, pre-filed testimony into the record.
Yes, all the pre-filed testimony of Mr. Kimbrell. Any objection?
No objections, Chair French.
All right, Mr. Kimbrell's pre-filed testimony will be admitted.
Thank you. At this time, staff tenders the witness for cross-examination.
Mr. Ely, the witness is yours.
Thank you, Chair French. Mr. Kimbrell, you know me quite well already. But my name is Jackson Ely. I represent the operator in this proceeding, obviously, and I'm going to ask you a few questions about your prior testimony. I will say this is the first time I haven't seen you in a tie, so this is a new for me.
One of the
Mr.
benefits of being a witness is not having to wear a tie.
Mr. Kimbrell, you previously served as litigation counsel for staff in this proceeding until you recused yourself so that you could testify as a fact witness. Is that correct?
I don't believe I accused myself, but I am no longer the lead counsel.
Okay. But you are testifying as a fact witness now, correct?
Yes. Yes.
Okay. Before you served as litigation counsel for staff in this proceeding, you also served as litigation counsel for staff in the 3030 case. Is that correct?
Correct.
Was operator represented by legal counsel in the 3030 case?
Not that I am aware of, no.
So Mr. Patrick was effectively operating as a pro se litigant in that matter, at least to the extent that he could on behalf of an entity like Patrick Development Corporation. Is that a fair statement?
As far as he could, as he's representing a corporation, and so I don't believe that he really could represent a corporation as an attorney. I believe he would need a separate attorney to represent that entity.
During the time period following the entry of the penalty order in the 3030 case on August 9, 2022, up until the moment that you became aware that operator retained legal counsel in this proceedings, you had significant correspondence with Mr. Patrick, correct?
We talked on the phone a couple of times and we did exchange some emails, yes.
Okay, and for the purposes of clarification, I am not in any way accusing you of improper communication with a represented client. I believe that the evidence speaks very clearly. You stopped that when you learned that Mr. Patrick was represented. Is that correct?
Well, I believe Mr. Schlatter indicated that it was okay for me to continue talking with Mr. Patrick, but I believe I CC'd Mr. Schlatter on all of my emails to Mr. Patrick after that point.
There was nothing wrong with your communication, I guess is my point, right? Okay. Is it fair to say that you were very knowledgeable about the 3030 case and the documents relating to that case and the facts of the 3030 case?
Objection. What's the relevance of discussing the 3030 case whenever we're here for a different matter, 233169?
If I may, it's because this matter, 3169, expressly ordered compliance with the 3030 case. It's important to know what operator did or did not do to be in compliance with the 3030 case. And during the time period at issue, operator was in correspondence with Mr. Kimbrell. And I think it's important to know what Mr. Kimbrell knew about the 3030 case when he was talking to operator while operator was trying to comply.
I mean, I was trying to see if you could get there. It just, you haven't got there yet, in my opinion, as far as getting to a relevant discussion about this docket, which you've claimed is an issue of notice of license suspension. So.
Well, if the commission extends me a little bit of leash, I will get there very quickly.
I'm gonna overrule to give a little leash, but I agree the underlying substance of 3030 does not appear to be the subject of this proceeding, but we'll let you proceed a little farther. So to that extent, I will overrule.
Thank you, Chair French. Mr. Kimbrell, is it fair to say that you were knowledgeable about the 3030 case and the facts and the dockets related to that?
I mean, knowledgeable in as far as I am knowledgeable of any kind of 111 penalty order. I do hundreds of them a year, and so I can't say that I know every detail about those penalty orders.
Did you know about the two sets of TA applications for the Bodley Pringle 7 and Johnson 7 wells, which were submitted in May and August, respectively?
I did not know about the second set until after the penalty order had been issued.
Which penalty order it issued?
So my understanding was you're asking about the TA applications?
Yeah, the August TA application. When did you learn about that?
At some point after the 3030 penalty order had been issued.
Okay. Did you know the reasons why those TA applications were respectively denied?
I don't believe I checked. I probably would have seen the letters that were attached to them, but beyond that, I wouldn't have taken any interest in why they were denied.
If I may share my screen here. Mr. Kimbrell, can you see what's marked as Operators Exhibit 2A?
Yes, I can.
And the letters that you reference, I'm going to scroll down to Exhibit 2B, and I'm going to show you the letter dated May 26, 2022. Is this one of the letters that you just referenced?
Yes.
And I'm going to scroll down to Operators Exhibit 2C. And the denial letter for the August set of TA applications, is this another one of the letters that you just referenced?
Yes.
So you would have seen the reasoning listed on both of these letters.
I don't remember if I actually looked at the second set of letters. I probably just saw that there hadn't been an approved TA in our database.
Mr. Kimbrell, when did you become aware that this August set of TA applications was denied specifically because there were not caps or swedges on the wells?
That I do not recall.
Did you learn of that during your correspondence with Mr. Patrick?
I don't recall.
But you knew that the second set of TA applications in August, they were denied, at least on August 16th. You know that happened, right?
Yeah, in our database, it would have said denied.
Okay. Just gonna pull up your pre-filed testimony here. Give me a second. Mr. Kimbrell, I'm on page 4 of your pre-filed testimony, the only set of pre-filed testimony that you submitted. It's titled rebuttal, but there was only one. So I'll just refer to it like that. On page 4, line 7, you stated that COLAR automatically generates and sends emails to operators when TA applications are denied. You said that, correct?
Yes,
Is the purpose of that COLAR automatically generated email so that operators are prompted to go look at COLAR and figure out what's happening with their TA applications?
I believe so.
So essentially, COLAR generates this email, and this email is what serves as notice to the operators to go look at COLAR and address whatever they need to address. Is that a fair statement?
Yeah. Yes, I believe so.
Okay. I want to go back to your pre-filed testimony. Page 4, line 12, you were asked about what you told Carrie Patrick about operators' compliance with the 3030 case. And your response was, quote, every time I spoke with Mr. Patrick on the phone regarding docket 233030, I told him that the penalty order in that docket required him to pay a $200 penalty and bring the Bodley Pringle 7 and Johnson 7 wells into compliance by plugging, returning to service, or obtaining TA status for the wells. You said that, correct?
Correct.
Okay. So in your correspondence with Carrie Patrick, you were telling him essentially that he needed to be in compliance with the 3030 case, correct?
Correct.
Did you ever tell him specifically that he wasn't in compliance? How specific? Let me rephrase. Did you ever tell him how specifically he wasn't in compliance at the Bodley Pringle 7 and Johnson 7 wells?
Not that I recall. I believe every time I spoke to him, I just simply said he'd need to bring the wells into compliance and pay the penalty.
Okay. I share my screen, and I'm going to show you what's been titled Operators Exhibit Number 4. That's attached to the pre-filed testimony of Carrie Patrick. These are data request responses. Correct, Mr. Kimbrell?
Hold on a second, let me get there.
And for purposes of what I'm going to do, I'm going to go down to responses number 17 and 18, if that helps you.
So the answer to your first question, yes.
They're data request responses?
Yes.
Okay. I'm going to go to request 17. Actually, before I do that, let me ask this question. Were these discovery responses put together after the commission ordered staff to produce information pursuant to operator's motion to compel?
Objection, argumentative.
I would state that it's a timeline, when Mr. Kimbrell produced this information.
And why is that relevant?
This information operator believes is adverse to Mr. Kimbrell and it's exculpatory to operator. Mr. Kimbrell was the one who initially objected and didn't willingly produce the information. Just wanting to point that out.
Okay, well, the commission can take note of when this information became part of the record.
Okay, thank you, Chair French. Mr. Kimbrell, in request 17, staff was asked, please admit that Tristan Kimbrell did not notify Carrie Patrick or operator that operator's TA applications were denied. And the response was, this allegation is admitted. Is that correct?
Correct.
And for request 18, staff was asked, please admit that Tristan Kimbrell did not, prior to the issuance of the shut-in order and docket 23 CONS 3169 CPEN, notify Carrie Patrick or operator that caps or swedges were required on the wells at issue in order for any TA application to be approved. The response was, this allegation is admitted. Is that correct?
Correct.
And I'm sorry if my Zoom cut out. I actually didn't hear a response from Mr. Kimbrell on that.
Correct.
Thank you, Mr. Kimbrell. I might have taken that down a little prematurely. I'm trying to put back up that same exhibit that I had on request 17 and 18. Mr. Kimbrell, in both responses, staff points to letters, the last one of which was sent on August 16, 2022, for the information that was provided to operator. Is that correct?
Correct.
So the last information that was provided to operator was on August 16th about these issues, correct?
I believe so through Kohler, yes.
Okay. So, Mr. Kimbrell, throughout all your correspondence with Mr. Patrick, after the 30-30 penalty order was entered and leading up to the entrance of the shut-in order in this proceeding, you never actually told Carrie throughout all this correspondence that the TA applications have been denied and that operator needed caps or swedges on the Bodley Pringle 7 and Johnson 7 wells, did you?
I believe I told Mr. Patrick he needed to bring the wells into compliance and pay the $200 penalty.
But you never specifically told him how they were out of compliance or that he needed to resubmit TA applications, did you?
No, I just told him that they were out of compliance and they needed to bring them into compliance.
All right, I'm going to share my screen again. This is Tristan Kimbrell. This is the pre-file testimony of Tristan Kimbrell, I'm sorry, at page 8. On page 8, line 16, Mr. Kimbrell, you state, I tend to assume that an operator is aware of the TA status of the wells in its own well inventory. Did you say that?
Correct.
I am trying to show what has been marked as operator's exhibit number 5, which was submitted with the pre-filed testimony of Carrie Patrick. This is an email. Mr. Kimbrell, can you see what I have shared on the screen?
Yes, I can.
Okay. Who is this email from?
From Mr. Patrick.
Who is this email to?
To me.
What is the date of this email?
September 30th, 2022.
And the next email in the chain, it's down here, but I'm going to scroll down to this page, which just has that one email for clarity. This is on the same date, correct?
Yes.
And this is from Mr. Patrick to you, correct?
Correct.
Can you please read the second to last line in the body of the email beginning with the word all?
All the
Objection.
TA,
I don't know how this is relevant to the docket, and this email appears to be about a separate docket that is now closed.
As I would state, the issues in this docket is whether or not operator was compliant with docket 3030. Operator's defense is that it did not know that it was non-compliant. This is an email correspondence from operator to staff, specifically talking about the efforts that operator made to try to be compliant with the 3030 docket. I think it is highly relevant, and it is absolutely something that we can discuss.
Well, if this was docket 3030, then that would make sense. The issue here isn't whether operator was or was not in compliance with the 3030 docket. The issue is whether, the issue that you've claimed is whether or not operator had notice of the suspension from docket 3030.
This issue goes to notice of whether or not operator knew it was not compliant or not. The reason why we're in this situation is because operator didn't know that it was non-compliant. This is evidence that goes directly to that. It directly addresses what operator knew in the time period immediately leading up to the entry of the shut-in order. This is after the docket in 3030 was entered.
All right. I'm gonna allow a few more questions on this. I'm gonna continue to say this is pretty attenuated. I tend to agree that as I understood your statement in opening, Mr. Ely, it was not disputing the validity of the suspension that resulted from 3030. It was the subsequent question. So I am having a bit of difficulty making the leap to the relevance here, but if you want to ask Mr. Kimbrell some questions about this email exchange, I think I understand where you're going. I'll give you a little leash to ask a few questions. So to that extent, again, I'm going to overrule it and give some latitude here. But please try to be succinct. Don't spend too much time having the witness just read the email. We can read the email. But if you've got questions about what was written that can kind of move us along, that could be helpful. But please proceed.
Yes, Chair French. Mr. Kimbrell, in this email, did operator inform you that it thought that all the TA work on the wells had been done and was filed at COLAR?
yes.
There was an attachment to this email, correct?
I believe so, yes.
I'm gonna scroll down to that attachment, specifically at paragraph number 8. This was what purported to be a motion for reconsideration filed by Mr. Patrick on behalf of operator at that time. Paragraph 8 states, operator completed and submitted the necessary work for temporary abandonment status to be renewed on these wells prior to receiving this penalty order. Is that what that email says, Mr. Kimbrell?
The motion, yes.
Okay. Mr. Kimbrell, do you understand those statements that Mr. Patrick told you that he believed that operator had already completed all the work that was necessary to bring the Bodley Pringle 7 and Johnson 7 wells into compliance on September 30th?
That's who we put in those statements.
Did you know at that time that operator was not correct on that?
I don't think I checked.
So you didn't correct him in any way?
No, I think, as you said, I emailed him back a few minutes later, telling him how to properly file that motion. So I don't think I checked. It was, I think I emailed him back, 11 minutes later. So I didn't check that he was mistaken. I wanted to make sure that he got that filed.
And you don't remember when you found out that the reason for the denial for the August 16th TA applications was because of the caps of the switches? Is that correct?
Objection asked and answered.
I'll move on. Mr. Kimbrell, can you assume that an operator is aware of a TA status on its wells when its principal agent is affirmatively telling you that he thought he had done everything?
I wouldn't want to assume what Mr. Patrick did or did not know.
point this out again, Mr. Kimbrell. Did you state in your pre-file testimony that you assume what Mr. Patrick did or did not know?
No, I tend to assume that operators in general.
Okay. Mr. Kimbrell, did you find out about the caps or swedge requirement for the TA applications for the Bodley Pringle 7 and Johnson 7 wells prior to the penalty order in this matter being entered?
I don't recall.
All right, I am sharing my screen. I'm trying to show what's been marked as Operators Exhibit 3C as filed with the pre-filed testimony of Carrie Patrick. Can you see that, Mr. Kimbrell?
Yes, I can.
Okay. Who is Paula Murray?
She's the legal assistant for the Conservation Division.
In this email, does Mr. Patrick notify Ms. Murray about a letter from the KCC arriving damaged in the mail?
Yes.
When was this email sent?
September 27th, 2022.
Now, that's prior to the suspension letter, correct? On
Yes.
November 7th.
Yes.
I'm going to scroll down to Operators Exhibit 3D as it was attached to the pre-filed testimony of Carrie Patrick. This is essentially the same email, but forwarded to you, correct?
Correct.
Scroll down to Operators Exhibit 3H. Who is Desiree Mayfield?
She's in the docket room, I believe.
Is that the room that's responsible for sending out letters?
It depends on the letters.
Are suspension letters sent out from that docket?
No.
Who are suspension letters sent out from?
The Wichita office.
Who specifically in the Wichita office?
Paula Murray creates the suspension letters.
Okay. Paula Murray is a recipient on this email, correct?
Yes.
Okay. And she, I'm assuming, is also a member of staff?
Yes.
If I go down to the oldest email in this email chain, this email indicates that staff was trying to send mail to operator and it was being returned to it, and staff doesn't really know why. Is that a fair assessment of that email?
Yeah, I think that's a fair assessment.
I'm going to go up to the email at the top, or at least the two emails at the top, and Paula Murray and Desiree Mayfield are discussing that they've never seen that message before in regards to the mail, and that the post office is going postal again. Is that correct?
Yes.
Objection outside the scope of Tristan's testimony.
I would state that this is a document that goes directly to the notice and the mail that was sent. I think it's important to know what staff, particularly Paula Murray, the staff member who's responsible for sending these letters out, knew about the mail issues. It was referenced in Mr. Kimbrell's testimony, all the mail that was sent out. This is a part of that mail.
I'll overrule for now. It's what's in the document. It's a document of the KCC. So if you can continue with a question for Mr. Kimbrell, that would be helpful.
Thank you, Chair French. I'm going to go down to Operators Exhibit 3I. Mr. Kimbrell, this is an email exchange between Nancy Borst and Paula Murray, correct?
Correct.
And Nancy Borst is also a member of staff, I assume?
Yes.
In this email chain, does staff discuss the mail issues that operator was having and discuss that it would be a good idea to both email and mail copy of correspondence to operator? Is that the
The
subject?
one, no, it's just talking about the one letter.
But
that
in,
was
at
sent
least
to
in
Mr.
that one
Patrick.
letter, staff stated that it would be a good idea in this case to send the email and mail copy.
Yes,
Correct?
for that one specific letter. Yes.
Share my screen again. I had pulled up, Mr. Kimball, your pre-filed testimony. This first item specifically is what has been marked as Exhibit TK1. This was an email that was sent to operator, correct?
No, he forwarded it to me. Is that what you're asking?
Yes, I'm sorry. Let me rephrase. The subject email that was forwarded to you, that was an email that was sent to operator, correct?
Yes. Mhm.
If I go down to Exhibit TK2, this was also emailed to operator, correct?
Emailed and mailed, yes.
If I go down to Exhibit TK3, this was also emailed and mailed to operator, correct?
Correct.
If I go down to Exhibit TK4, this was also emailed and mailed to operator, correct?
Correct.
If I go down to Exhibit TK5, this was also emailed and mailed to operator, correct?
Correct.
Mr. Kimbrell, was staff generally emailing things both via email and via physical mail to operator?
Staff was emailing and mailing those specific documents because it related to Mr. Patrick's attempt to request a hearing, and the time was growing short for that. And so they wanted to make sure that he got that email denying his request for hearing in plenty of time for him to submit a request for hearing in a timely manner. That's why it was being emailed to him.
Mr. Kimbrell, I'm back on your testimony. I'm going to scroll up to page 7, your pre-filed testimony at page 7. Beginning at line 17, you were asked, does staff normally email license suspension letters to operator? And your response was no, staff mails license suspension letters via first-class mail. Staff does not email such letters or call operators regarding such letters. Is that correct?
That's correct.
Mr. Kimbrell, did staff ever call, email, or seek to follow up with operator to see whether or not operator got the suspension letter in the mail?
Followed up by Kohler indicating that his license was suspended and that the public website for the KCC indicated his license was suspended.
When you say followed up by Kohler, how do you mean that?
The name Patrick Development Corporation would have turned red, indicating that the license had been suspended.
I'm going to circle back around to the Kohler in a minute, but let me finish kind of my line of thought here so I don't get too messed around. Other than the suspension letter that was sent on November 7th, are you aware of any other document that was sent to operator since the entry of the penalty order in docket 3030 on August 9, 2022, which was not also sent via email to operator?
Not that I could think of, no.
Mr. Kimbrell, I am showing you the suspension letter that was purportedly sent out on November 7th, and I think you might have already addressed this, but I just want to be clear. Was it Paula Murray who prepared this letter?
Yes,
And Paula Murray sent the letter out?
yes.
Did you witness Miss Murray sending the letter out?
No, I did not.
Do you know with absolute certainty that this letter was sent in the mail with proper postage addressed to operator?
I don't think you can know anything with absolute certainty, Mr. Ely.
Did you? I'll move on. Mr. Kimbrell, I want to circle back to a comment you made just a little bit ago regarding Kolar. You said the operator's name changes colors in Kolar. Am I understanding that correctly?
Yes, I believe when their license is suspended, it turns red.
Okay. And so an operator logging into Kolar would see that its name is red and would just know that its license is suspended because of that. Is that correct?
I believe most operators would realize that something was at least amiss and would call, but I believe most operators are aware that a red name means that a license has been suspended.
And then you also stated that the license suspension list is on the KCC's website. Is that correct?
Well, all the operators in Kansas are listed on the KCC website, and if they're active, it indicates active. If they're suspended, it indicates inactive.
Mr. Kimbrell, you had testified previously that when a TA application is denied, Kolar automatically generates an email that prompts operators to go check Kolar. Is there an automatically generated email when a license is suspended?
Not that I'm aware of.
Is there any automatic email that's generated that prompts an operator to go check the KCC's website?
Not that I'm aware of.
So when an operator's license is suspended, there's no email that's sent out that prompts operator to check any website, is there?
Not that I'm aware of.
Mr. Kimbrell, in the license suspension letter, operator was given 10 days between November 7th and November 17th to become compliant. Is that correct?
Not exactly. Once the license is suspended, they need to stop operations immediately. The letter says that staff check after the 17th to make sure that there is no more operation.
Mr. Kimbrell, do you think it's reasonable that an operator who thinks that nothing is wrong is obligated to go unprompted and check Kolar or the KCC website every 10 days?
I think most operators check Kolar every day.
Mr. Kimbrell, you had been in contact with Mr. Patrick in late October, were you not?
Like by phone call or via email? What are you referencing?
Were you in correspondence with Mr. Patrick in late October?
I'd have to check the emails to see. I don't recall specifically.
Okay. Give me just a moment here. Let me rephrase this question for the sake of time. Mr. Kimbrell, are you aware of anyone from staff, including but not limited to Paula Murray, being in contact with Mr. Patrick in late October? Are you aware of that?
Could you tell me specifically who you're talking about or reference something? I'm not positive if anyone would have been.
I'll share this just for the sake of it. This is
Okay.
one of the exhibits that was, I believe, attached to Mr. Patrick's pre-file testimony, specifically Exhibit 3N. This is just demonstrative. I believe there were also exhibits that were attached to your own pre-file testimony, which indicate that the commission was sending letters to Mr. Patrick in at least late October. Is that correct based off of reviewing that document?
Based on this document in front of me, the October 26th letter sent by Paula Murray, I would agree that Paula Murray had sent a letter and an email to Mr. Patrick on October 26th. Yes.
Okay. Mr. Kimbrell, before the license was suspended on November 7th, did you ever try to reach out to Mr. Patrick and tell him that operator's license was suspended?
No, I didn't. Wait, did you say before November 7th?
Before November 7th.
No, I did not reach out to him to tell him that his license was suspended before it was suspended.
During the period between November 7th, 2022 and December 29th, 2022, did you reach out to Carrie Patrick or anyone on operator to inform them that operator's license was suspended?
No, I did not. I should amend that. By reach out, means me specifically giving a call or an email, because obviously he was sent a letter and there was indications through Kohler. So specifically, I did not email or call Mr. Patrick, which I assume is what you're trying to get at.
Yes, thank you for clarifying, Mr. Kimbrell.
Absolutely.
I'll share my screen again here. This is what was attached to your pre-file testimony as Exhibit TK7. You did have correspondence with Mr. Patrick on December 29, 2022, correct?
Yes, that is correct.
And that's the day that the shut-in order in this proceeding was entered, correct?
Yes, it was.
In this email, did operator indicate that it had put caps or swedges on the two wells at issue?
Well, it references the penalty order. I'm assuming it's referencing 3030. He doesn't specifically say that. Everything is a reference to 3169, but I assume he's referencing 3030 by saying that he did put caps on the wells, yes.
Based off your understanding of this email that you received, did you understand the term wells to indicate the Bodley Pringle 7 and the Johnson 7?
I do not recall. I assume that I thought as much.
So at least according to the email that you were sent, operator purports to have fixed the issue the day the shut-in order was entered. Is that correct?
Objection. What's the relevance of this line of questioning? Because this would have happened after staff had already found operator operating on a suspended license, and it would have been after the license suspension letter had already been sent.
If I may, operator is facing a heightened penalty order. Sorry, I heard the recording stop in progress. That threw me off. If I may, operator is facing a heightened penalty order in this subject, allegedly because of a history of noncompliance. This email indicates that Mr. Patrick brought the operator into compliance within 24 hours of finding out about it. I think the speed at which he attempted to come into compliance when he learned about it is a factor that needs to be considered in whether or not a heightened penalty order is justified.
I don't know if that makes sense, though, because we're talking about December 29th when the penalty order was issued August 9th. We're talking about months after the penalty order was issued.
I'll allow it as a potential mitigating circumstance, but again, it's pretty attenuated, Mr. Ely, so let's not spend too much time on it.
Thank you, Chair.
Overruled.
Was there a question?
Yes, Mr. Kimbrell. According to this email, did operator purport to fix the issue the day it found out about the shut-in order in this case?
Well, it purported, Patrick Development purported to put caps on the wells, but there still was no CP 111 that had been filed or approved, as far as I'm aware. So the wells had not been brought to compliance, even according to
Mr. Kimbrell,
Patrick's email.
I'm sorry to interrupt you.
No, that's fine.
Okay. Mr. Kimbrell, this came up in Mr. Dooling's testimony. And let me ask you, did you inform District 3 staff of this email and operator purporting to put the caps or the swedges on the wells on December 29th?
Yeah, I'm afraid I do not recall whether I informed district staff of this email. It's a long time ago.
So how did district staff find out that the issue was fixed?
They would have found out through the CP 111s that Mr. Patrick had filed.
Mr. Kimbrell, I will say, I think I'm mostly done with my cross-examination of you. I used a couple of exhibits for Mr. Dooling that I would like to bring up for you and have admitted into the record. I don't really have a lot of questions on one of these. I have a couple on another. So just give me a moment here. And Mr. Kimbrell, I'm showing you what was marked as Exhibit PDX 7. Do you see your name and email address in the recipient section of this email?
Yes, I do.
It's fair to say that you received this email?
Yes,
Is this a true and accurate depiction of the email that you received?
I believe so.
I would ask that Exhibit PDX 7 be admitted into the record.
No objections.
The exhibit is admitted.
Thank you, Chair French. I'm going to go on here. Mr. Kimbrell, showing you what has been marked as, scroll to the top, as Exhibit PDX 9. Can you see that?
Yes, I see it.
Do you see your name and email address in the recipient section of this email?
I do.
And this is an email chain, presumably between yourself, Mr. Patrick, and my colleague, John Schlatter. Is that correct?
Correct.
Okay. Is this a fair and accurate depiction of the email that you received?
Yes, I believe it is.
I would like to offer PDX 9 into evidence, please.
No objection.
The exhibit is admitted.
Okay. Mr. Kimbrell, I'm going to go down a ways in this email chain to an email dated Thursday, January 12th, 2023 at 1:54 p.m. Can you see that?
Yes, I see that.
Okay. In this email, you stated that there was a concern regarding the fluid levels reported in the TA applications. Is that correct?
Correct.
Is that the reason why staff conducted a field inspection after January 4th, 2023?
No, my understanding is that they conducted that field inspection to make sure that there was surface control.
Why were there concerns about the fluid levels?
If I remember correctly, there was concern that Mr. Patrick had simply made up the fluid levels, that the Johnson number 7 well still had a string in it, and you can't do a drop line to find the fluid level, as he indicated in his CP 111. And so I believe there was concern that he had just merely made up that number.
How was that concern brought to your attention?
And I'm not sure at what point we're talking about attorney-client privilege. If Mr. Marsh would like to.
Object.
Yeah.
Fair. If I may, I will rephrase the question. And I might preface this a little bit because I expect another objection, and maybe Chair French can rule on this. Mr. Dooling testified in his testimony moments ago that there were no concerns about the fluid levels. I'm a little confused, and I would like to know where these concerns originated and how they got communicated to Mr. Kimbrell if it wasn't from Mr. Dooling. So I would ask at least who communicated the concerns about the fluid levels to Mr. Kimbrell.
Objection. I don't see how this line of questioning is relevant. Also, it includes attorney-client privileged information, probably calls for a little bit of speculation, lots of different reasons.
Yeah, I'm gonna give you sort of a mixed ruling here. I do agree. We're probably wading into some attorney-client conversations. I also think, though, there may be some confusion because I think we might be talking on different timelines, that at certain timelines, the concern was the fluid levels. And then it sounded like the other, the lack of surface control maybe surfaced at a different time. Is Mr. Ely, is that what you're trying to suss out, is the timeline of events?
No, Chair French. I had brought this specific email to Mr. Dooling's attention in his testimony just moments ago. I brought specifically this concern, and I showed this very same email to Mr. Dooling, and Mr. Dooling affirmatively stated before the commission that there was no concern about fluid levels. I'm less concerned about the timeline and concerned as to how there's a discrepancy between what Mr. Dooling is telling me and what Mr. Kimbrell is telling me.
Again, is it relevant?
Yeah, I'm reluctant to, Mr. Ely, I guess I have my own interpretation of that already, but based on what's in the documents, and I am a little concerned that I also don't understand the relevance, but I want to give you some leeway here. So why don't I let you ask Mr. Kimbrell again if he has any knowledge of conversations, but if we get too specific into, who brought this to you and what was your advice to them, what were your discussions? I mean, that's certainly attorney-client conversation. So if you want to ask him in generalities, whether multiple concerns were raised, I think that's okay. But let's not go too far, because I think you definitely will be wading into what would be properly objected to as attorney-client privilege matters at that point.
Yes, Chair French. Mr. Kimbrell, was the fluid level the only concern that was brought to your attention?
No, it was not.
What was the other concern?
The lack of surface control.
Was that brought to your attention by District 3 staff generally?
Yes.
I have no further questions for Mr. Kimbrell. Stop my share.
All right. Then it is time for commissioner questions. Commissioner Keither has gone off camera, so I don't know if she is gone. Oh, there she is.
I'm here. I just didn't think you needed to look at me all day long.
Do you have any questions for Mr. Kimbrell?
Not right now. No, I don't.
And I do not have any questions for him either. Mr. Marsh, do you have any redirect?
Yes, Chair French.
Okay, go ahead.
Tristan, do you believe that Patrick Development was provided sufficient notice of the license suspension in this docket?
I believe so. All license suspension matters are set out by first class mail, and there's notice on Kohler and on the KCC website. So it was the same as we do for every other operator.
Was there any language in the 23-3030 penalty order that discusses suspending an operator's license?
Yes, I believe in paragraph F, if you have that handy.
Ordering clause F?
Yes.
I do think I have that handy. And what does ordering clause F say?
The first sentence says, if operator is not in compliance with this order and the order is final, then operator's license shall be suspended without further notice and shall remain suspended until operator complies.
Mhm.
Okay. Is it a common courtesy still to send operators license suspension letters?
Yes, it's a common courtesy.
And was a suspension letter sent to Patrick Development in this docket?
Yes, it was.
Did that suspension letter ever come back to staff or come back as undeliverable?
No, it did not, as far as I'm aware.
Did staff handle this any differently than license suspension letters for any other operator?
No, it was handled in the same way.
Would a prudent operator check Kohler on a regular basis?
Yes, I believe as I testified earlier, prudent operators probably check daily.
And I know Mr. Ely mentioned exhibit PDX-9. There's a portion of it that stood out to me that I'd like to bring up and reference. Then Mr. Schlatter, who is Mr. Ely's colleague, send you an email saying that Mr. Patrick's Kohler account is still showing as inactive -- suspended status.
Yes, Mr. Schlatter did send me that.
So does that indicate to you that there was some sort of notice on Kohler indicating that Patrick Development's license was suspended?
Yes, the name would have turned red.
Is the commission allowed to issue heightened penalties to operators?
Yes.
And what allows the commission to do that?
I believe KSA 55-164.
Okay. Let's go ahead and pull that up just so we have it in front of us. And what specifically in KSA 55-164 discusses heightened penalties?
In A, it states that penalties shall constitute an actual and substantial economic deterrent to the violation.
Is it common for an operator to be assessed a heightened penalty for operating under a suspended license when operator has a history of operating under a suspended license?
The commission does tend to put in place a heightened penalty amount if there is a previous history of operating under a suspended license. Yes.
And does Patrick Development have a history of operating while under a suspended license?
Yes, in previous dockets.
I know it talks about $10,000 per day in 55-164. Is there any indication that Patrick Development operated under a suspended license for enough days to justify the commission's assessment of a $25,000 fine?
I believe so. So the license suspension went out on November 7th. There was a November 17th deadline before staff would start checking. And then Mr. Patrick indicated that he shut in his wells on December 29th. So I believe that's 42 days. So each day constitutes a new violation. So I believe that would certainly be enough to suggest that a heightened penalty would be appropriate, as well as the amount of oil that was produced by Patrick Development Corporation during that time period.
Do you happen to recall the amount of oil produced by Patrick Development during that time period?
I believe it was 553 barrels. You can correct me if I'm wrong.
Was there a dollar amount associated with that?
It was a bit more than $40,000, I believe.
Would a prudent operator know the status of the wells on its license?
I believe a prudent operator would, yes.
And I know Mr. Patrick's testimony, he states that he thought the applications were approved on August 16th. Do you recall that information?
Yes, I believe I recall him testifying to that in his pre-file testimony.
So if he thought that the wells were brought into compliance on August 16th, does it make sense for him to request a hearing on September 19th, 2022?
It might if he is trying to contest the penalty.
But would that still be an indication that he was aware of still being out of compliance, or that there were still issues that he needed to come into compliance with? Based on
Yes,
this?
I understand your question. Now, yes, that would indicate that he had not been completely into compliance with the penalty order.
Thank you. I have no further questions.
All right. I have to redirect. Is there any need for any additional recross?
I would like some, Chair French, on just a few pointed issues, if I may.
All right, we'll give you a couple minutes here.
Thank you. Mr. Kimbrell, you testified just moments ago with Mr. Marsh that other operators have these letters sent to them in the mail, and that's the standard procedure. Are you aware of any other operator who has affirmatively informed commission staff to the extent that Patrick Development did about the issues that it had with the mail prior to sending something out only via email or only via mail? I apologize.
No,
Mr. Kimbrell, you had testified a few moments ago as to the purpose behind a heightened penalty as being a deterrent. Mr. Kimbrell, does a deterrent only work if the party to be deterred knows it is doing something wrong?
I believe that's speculation. I'm not sure I want to go down that path.
Let me rephrase. Mr. Kimbrell, could Patrick Development have been deterred if it did not know that it was uncompliant?
Objection still calls for speculation.
I'll withdraw the question. Mr. Kimbrell, you had testified that, I believe you said 42 days operator was operating on a suspended license.
Yes, I believe that's correct.
Bear with me for a moment here. Assuming that we're counting from when Patrick Development learned of the penalty order on December 29th, how many days did operator operate when staff knew for certain that operator knew that his license was suspended?
Well, I believe there was oil sold on January 6th. And so
Does that mean that operator was producing wells from December 29th to?
No, it does not, but it means that operator was selling oil on January 6th after his license had been suspended.
How many days can staff? I'll withdraw that. Mr. Kimbrell, you had testified a few moments ago about Patrick Development contesting the 3030 order. And I believe the implication there was that by contesting the penalty order, there was an acknowledgement that Patrick Development was still non-compliant. Can an operator contest a penalty order and be currently compliant? Is that possible?
Not sure I've ever seen that, because I believe the docket would be closed once the operator is compliant. That would be a question that would perhaps be best for the commission to decide.
Let me rephrase the question. How does contesting the 3030 penalty order indicate that Patrick Development knew that it was still non-compliant at that time?
Well, as I indicated, it could just be that he thought that the $200 penalty wasn't appropriate. And so therefore he wanted to contest that, and that he believed the wells were in compliance. I'm not trying to indicate that he believed that one way or the other on the wells, but I think that if you're contesting something, then that suggests that you do not believe that you need to at least pay the penalty.
I have no further questions for Mr. Kimbrell.
All right. Any additional commissioner questions? Commissioner Keither?
I just would like to, if one can cite the regulation, if I'm correct, that an operator is responsible for providing a correct mailing address at all times. Is that correct?
I'm not sure that there is a specific regulation regarding that, but when operators renew their licenses, they are required to indicate what their mailing address is, and they are indicating that everything is true in that application, in that license renewal, and therefore that they are indicating that that address is correct.
Okay. Thank you.
All right, I don't have any questions. Mr. Marsh, is there any need for redirect?
I don't believe so. I think Commissioner Keither kind of touched on the one thing that I might have addressed.
All right, I think we are done with Mr. Kimbrell then. Thank you, Mr. Kimbrell, for your testimony today. You may step down and you are released. All right, let's see. We've been going for an hour, but I think we can go just a little longer. We are now ready for operator's witness. Mrs. Patrick, we have already admitted the direct testimony or all the pre-filed testimony of Mr. Patrick. Mr. Ely, before you call Mrs. Patrick, just a reminder, what we will do once you call her is I will let you just lay a little foundation of what her duties are with the company and what the scope of her knowledge of is the company, just enough for anybody that wants to ask questions to understand what scope of questions we could ask. And then we'll turn it over for cross-examination and commissioner questions. So at this time, please call your witness, Mr. Ely.
Thank you, Chair French. Operator Patrick Development Corporation calls Cynthia Patrick to the stand, please.
Good afternoon, Mrs. Patrick. If I could please swear you in, and I'll have you please raise your right hand. Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
All right. Mr. Ely, go ahead.
Thank you, Chair French. And I'm sure that if I stray over the line between foundation questions and direct questions, the commission will correct me.
I will let you know.
Thank you, Chair. Mrs. Patrick, can you please state your name and your business address for the record, please?
Cynthia Patrick, 3408 West 93rd Street, Leawood, Kansas, 66206. And you guys are welcome to call me Cindy.
Ms. Patrick, can you please summarize your educational and work experience?
So I'm a graduate from Kansas State University. I am a dietitian by trade, was in medical sales for many years, and have been a wedding coordinator for 25 years and run my own company.
Mrs. Patrick, who is Carrie Patrick in relation to you?
My husband.
Can you please describe your former or current role or involvement with the operator in this proceeding, Patrick Development Corporation, and if that role has changed recently?
So I'd say over the course of 10 years, I'm responsible for all the mail. We have a bookkeeper. I organize all of his mail, give it to Sherry Brinkley, who does our bookkeeping and our payroll every month, our taxes. It's changed when Carrie was diagnosed with pancreatic cancer 2 years ago, become much more involved in making sure when mail would come in that I would hand it to him, and then specifically make sure and I used to do his bookkeeping too, so I know a lot about like what bills are due and so forth, but very much involved in the day-to-day mail that comes in.
And what is your role now currently with Patrick Development Corporation?
I love to go down to the oil wells. I love James, but I always tell James I know nothing about oil, but I make sure he's got his car tags and taxes are paid, and again, make sure the bookkeeper has everything that she needs. It's very hard to explain to you guys how sick Carrie really is. I'll just take a deep breath on this one. The pancreatic cancer was a tough one, and the stroke a month ago was enough to just throw me over the edge.
Thank you, Mrs. Patrick. Do you share a mailing address with Mr. Patrick?
Yes,
During the time period at issue in this proceeding, did you live with Mr. Patrick?
yes. And Jackson, I even pulled out my 2022 calendar. I keep meticulous notes. I've kept all my books for the last 25 years to look at what was going on during November of, when all this was transpiring, just to make sure that I was in town in November and December when that mail was being mailed to us.
Mrs. Patrick, let me ask, who is responsible for retrieving and sorting the mail which arrives at you and Mr. Patrick's home?
So my son, Christopher, he moved in with us when he graduated in May of 2025. Carrie was down to 113 pounds. I asked my son if he would move in with me and just kind of be here to help me care for Carrie during that time. So I'm sitting at my desk right now. I have this little basket that either Christopher or we put the mail in every single day. So I am the person that goes through it. And I have to say to the KCC, you guys do, I kind of look at us as team. You are helping us keep our wells in good standing. And whenever I get a letter from you guys, I do not take it lightly. I from my heart, I told Jackson, I take it to Carrie. He opens it. And the first thing I say to him is, everything okay? Do I need to do anything? And at no time did a letter come in November or December. I even went through my notes to make sure that I hadn't been traveling. Maybe I had missed something. And when that letter came, the email came on December 29th. I mean, I've never seen Carrie move so fast to try to get the swedges on the whales, talk to James. And I just want to say honestly to all of you, Carrie would have never ignored something of that magnitude. I do believe, Carrie was diagnosed with MS 24 years ago. Probably some of the past fines that he had might have been because he was tired. Carrie doesn't even go to the oil fields anymore. I go down there and check on his employees. That's how sick Carrie is. But I do know this, when that email came in that day, he moved fast and was on the phone with James, and James got the swedges on the wells. And again, I will show you my entire month of November and December. I had not traveled. I was here. I was the one to go through the mail. I've been married to Carrie 28 years this May. I have never taken the KCC lightly, because if it wasn't for you guys, we wouldn't get paid every month. So I know the importance of when a letter comes, I literally hand it to Carrie. I don't open it and leave it anywhere. I hand it to him, because I know it's up to you guys whether we get paid or not. And with Carrie's illness, I believe he does the best that he can do.
Mrs. Patrick, thank you. I will kindly ask you, so that Mr. Marsh or the commission doesn't have to, please try to answer specifically the question that you're asked.
Okay.
I'll move on. Have you reviewed the pre-filed testimony of Carrie Patrick, which was previously filed on this proceeding?
Yes, I've reviewed it a few times.
Do you believe that Carrie's pre-filed testimony is true and correct to the extent of your knowledge?
Absolutely.
Are you willing to generally adopt the portions of Mr. Patrick's testimony in regards to the notice and the mail that might have come to your home? Are you willing to adopt that testimony as your own?
Yes.
During the period of November 7, 2022 to December 29, 2022, did any mail arrive at your home purporting to be a license suspension letter from the KCC?
All right, I think I am going to go ahead and stop at this point, Mr. Ely. we've definitely gotten enough to understand the scope of Miss Patrick's role within the company. So I think this will allow folks to ask questions. So I appreciate it. All right, at this time, I will turn to Mr. Marsh. Do you have any cross for Mrs. Patrick?
I do not, Chair French.
Commissioner Keither, do you have any questions?
No, thank you.
All right. Well, I don't either. So I think that's as quick and painless as it can be, Ms. Patrick. We do thank you for your time and your testimony today, and you may step down virtually. You're released.
And I do thank you for what you guys do. So,
All right. Thank you.
okay.
Okay.
Jackson, do you want me to stay off or get off?
Cindy, you can mute and you can stay on if you'd like. I don't think that there's much left, but that's Chair French's decision.
Okay.
Yeah, this is an open hearing. You are welcome, and it's your hearing. So you are certainly welcome to stay on through the end. All right, we have finished the examination of witnesses, and we will now move to closing statements. Mr. Ely, do you want to begin for the operator?
Chair French, operator is willing to waive closing statements and just proceed to filing post-hearing briefs. It sounds to me that the issue here primarily is going to be sufficient notice. That's a legal question.
Okay.
I believe that we can address that most effectively in post-hearing briefs and not
Why?
closing statements.
That is fine with me. I had some indication from your pre-hearing conference that the parties may want to do a little briefing. Why don't we, instead of trying to hash out a briefing schedule at this moment, why don't the parties confer with the pre-hearing officer, Mr. Myers, over email within the next day and establish a briefing schedule? I'm envisioning probably a brief from Patrick, a response from staff, and a reply from Patrick if you wish to do it. Something that's not too elongated, because I think the issue is pretty limited in this case. I mean, it's should be pretty limited briefing. Is that acceptable to both parties to confer with Mr. Myers within the next 24 to 48 hours and establish a briefing schedule?
That
That's
works
fine.
for operator.
Okay, and we'll just have him issue a pre-hearing officer order memorializing that after you all confer. With that, since we've nailed down briefing, let me just ask if there are any final post-hearing issues that you all want to address before we conclude. All right, seeing shaking of heads, this will conclude our hearing in this docket. At this time, we will close the record and adjourn. I thank you all again for your participation in this hearing. Have a great day.
Thank you.